Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
We're getting commentary on the case. Dati mihi Anglican operates service.
Scratch all that. Oh, that was terrible. I apologize.
It helps if I look at the buttons before I push them. I found that works better out. It works out better for me. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Great to have you here with us this morning. I see everyone has come in. The front row is nearly full, but a few seats remain. Please do take your seat if you have reserved seating. I'm going to start early with the water. All right. We're good. We're good. Wonderful morning. Good morning. My family up and left me today. Everybody's gone, and they took all the cars. So it's just me and you today. This is what we got. It is what it is. I didn't know this was a thing, but the kids are headed to a museum today on a field trip.
I'm not a camel.
And it's a bug museum. I didn't know we had a bug museum in North Carolina, but apparently there's a lawsuit. There's a museum all about bugs. I thought how appropriate, and all the better that I'm not there. I think all the better that I'm not there. So, yeah, they're gonna have fun. I'm sure. My kids love bugs. Unfortunately, let's see.
Somebody just sent me a video of roaches fighting.
Yeah,
I don't know who won.
When are we gonna break for lunch, Judge?
I was kicked back,
taking
it
show
easy.
The Southern Febreze creative beat. I hope so. I hope they have a lot of it. All right, welcome to. Oh, that's not gonna work. Apparently, I have to have all the buttons pushed. Wait for it to connect. 3, 2. Oh, and apparently, internet is also important for this to function properly. And this thing's so demanding. There we go.
I'm not a camel.
Now we can bring up C. Chinny. Congratulations. I believe this is the first time for you, first time offense, that you were first in chat.
Someone with more experience.
Not sure if you knew this. Me might have just stumbled in on accident early and not been aware, but the first person in chat every day is penalized with internet ownership to teach them a lesson. Let them know that it's, well, actually we enjoy it, but socially, it's not acceptable to talk the first person in chat. You know, that's like breaking a silence. It's similar to breaking the law, and so we punish it accordingly. We are going to grant you or punish you, I guess, with internet ownership for the rest of the day. You're just responsible for everything on the internet and connected to it. It's a small task, but just add it to your daily to-do list and make sure it keeps working for the rest of us, and none of us will complain. I can't speak for the others, though. They may complain. You may get a lot of calls. Congratulations, C. Chinny. If you would like to commemorate this amazing win of being first in chat, over on our merchandise page, for the low fee of 50 cents, you too can download your own fill-in-the-blank internet ownership certificate, which is signed by both myself and Mrs. R.A., my boss. So help yourself to that as well, if you so choose. Just know that we're going to keep it on your permanent record anyway, whether or not
Don't
you
miss
get
the
that.
forest for the trees.
All right, party at a Recovery Addict's house. Yes and no. I'd say yes because there's plenty of room. Come on over. No, don't really. That would be bad. I'll call the police. But I'm a terrible host. I'm a terrible host unless you want water. That's about all I can offer. Water and a tour of the Airbnb, which hopefully will be rented here in the next 24 hours. All right, let's see. Kim, you still have not gotten your internet certificate?
Somebody just sent me a video.
50
of
cents at a
roaches
download.
fighting.
That's all I
don't
can
know
say.
why.
It's a fee. It's a fee. It's like a fine. It's like a fine. None of the money goes to me. It just goes to the costs. All right, we have a couple birthdays to celebrate this morning, so we're going to get ready to do that. Now, you guys, please warm up your voices now appropriately. Elizabeth Duguid, Nina, both have birthdays today. Elizabeth and Nina. So we're going to sing to the two of them. This is, as I've said before, I think you should know this. This is not me singing alone. This is not a solo birthday serenade. This is a group choir, possibly the largest birthday choir in the world. I like to think that it is. But this is all of us singing to Elizabeth and Nina. So please join your voices with mine as we sing to celebrate their happy day. Remember your part. Shoulders, shoulder, head up, chin up, deep breaths. Breathe with your diaphragm. La 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 la. Here we go. Blend your voices, people. Blend your voices. Happy birthday to you. Happy birthday to you. Happy birthday, Elizabeth and Nina. Happy birthday to you. A little bit different version. Did I miss somebody else's birthday? Let's see. Happy birthday, everyone. Cha-cha-cha. To those who are celebrating, especially Elizabeth and Nina, have a wonderful birthday. Let's see. Sunshine says, morning. Can you say happy birthday to my son, Ryan? Ryan, who's 15 years old. Happy birthday. Sunshine B says it's your birthday, so it must be so. Happy birthday. You have a great parent. We call you out. Call you out on the internet. 15. Wow. That's a big year. 15's a big year. It's still a fun year. So enjoy it, and be good to your parents. Thank you very much. Have a happy birthday. All right, we will, let's see. Today's my son Ansley's birthday. Ansley, happy birthday there as well. Lindsay Lewis, your son Ansley has a birthday today. Wonderful. Tracy, it's my birthday. Oh my goodness, so many birthdays. I missed all these people in the birthday song. Happy birthday to Tracy as well. Will you really call the police? In a heartbeat. I am so protective of my family. I could tell you a story about my brother-in-law coming over unexpected. And I drew down on him. I'm just saying. He had a key to the house from a long time ago, and when he was staying with us briefly, and he thought it was late, so he wouldn't knock, and he just came in, and he tried to come in, and I met him at the door. All right, Tony, Tracy also have birthdays today. Robert Hamilton, happy birthday, 37, big 37, lots of birthdays. No need to sing to him, but it's my eldest grandson's 13th birthday, says Nan R. Happy birthday to your eldest grandsons. There we go. We've never got to the end of the birthday song like this year before. Loads and loads of birthdays. Yes. Yeah, I'm very protective. Coming to my house is probably not the best thing to do. I've got kids, and I don't recognize people. So anyway, that's it. All right, so I ended the birthday story with a threat, so that went well. Oh, what a day! All right, let's see. Where are we going? Let me tell you what we have. I actually wanted to cover just a little bit. There's news. Look. Oh, wow. Talk about a birthday. Look, a birthday is today for Francisca Cruz Arancibia. My niece was born at 4:09 today, so this is actually her birthday. Maria Lourdes is her name. Wow. Happy birthday. Happy 0th birthday. Their first birthday, which is actually like not really counted. Sorry, nobody gives you presents on the day you're born. It's just celebrated after that. Tony, Tracy both have birthdays. Thank you, Sharon, for rounding all those up. So many birthdays today. I hope all of you have a absolutely wonderful birthday today. And sorry about the sting at the end of the birthday song. Love it. That is wonderful. What a great day. What a great day. Day before Valentine's Day. In case you forgot, now is the last chance to order your next day delivery for anything anything you're getting, whether it be an appliance, which I don't recommend. I've heard from a friend that you don't get your significant other an appliance on Valentine's Day unless they really, really want it. And make sure, because you just thinking they might want that is probably not good enough. I wouldn't recommend. 0 out of 10. All right. Happy birthday to your niece, Fran. Where's Fran? Oh, there it's. Oh, right there. Thanks, everyone. I'll tell my sister your love and congratulations. That's exciting. All right, we have a fun day. We have actually an announcement in the Idaho 4 case, which is one we're going to be following. We're going to put this on the calendar as it comes up. Let me see if I can bring this up on. Okay. Let's see if I can pull this up on Twitter. X. See, when you search for X on Google, it doesn't find anything. It's like, do you want XLR explained? Oh wait, there it is. There's Twitter. Okay. One of the many sources we use. We have some amazing document hounds here on Discord and everything else. I follow a couple accounts on Twitter as well that tweet out some documents from the cases that we are following, and this one I happened to see from them first. Let's see, save image as. Yeah. That. Now where did it go? I saved it and now it's gone. Oh, there it is. Found it. Never mind, guys. Call off the alarm. Here we go. We need a blank screen there. Got it. And see if I can make this big so everyone can read it. Of course, the graphics are terrible, but there we go. Okay. Let's take this. This is an update, a little filing that was made in the Brian Koberger case, the Idaho 4, for those that are following. BK has it's on the back burner because it's pushed out to possibly 2025, maybe March-ish, and that's a tentative date. This might have some impact on that. Based on defendant's motion to allow certain experts and investigators protected access to view IGG material, defendant's motion requesting clarification of the sealed order for disclosure of IGG information and protection order, and the state's request for a scheduling order, the court orders the following. Basically, we've got a whole bunch of work to do, and because of that, the court orders the following. So this comes from the judge. A hearing on the above motions is set for February 28th, which is, 15 days, 2 weeks from now? February 28th. At 1 p.m., this hearing will be open to the public and will be live streamed on the court's YouTube channel and on ours. As to scheduling, counsel shall be prepared to adjust scheduling, both a briefing schedule and an oral argument on defendant's motion for change of venue, a discovery cutoff deadline, expert disclosure deadlines for filing any pretrial motions, such as motions to suppress or motions in limine, and dates for a trial. That last part, the dates for a trial, is what we're super interested in. But also the first part, the change of venue motion, we've had this brought up in the last hearing that it's possible that maybe this courtroom, judge's courtroom, is not the best place to have the trial. And it might not be the best place to try to seat a jury. So I think that of all court cases we've seen, this will have a very, very high likelihood of getting a change of venue. What does that mean? New judge? No. It means the judge goes to the other place. He becomes a traveling judge for this case only and will move possibly to a larger courtroom nearby. And I'm not sure how many counties away they would be considering moving for this, but they would basically just rent a space in another courtroom and take up this trial. So a change of venue is very likely, but that argument is going to be made on the 28th. Some of the other things you remember from the last hearing we had for Brian Koberger, the defense attorney was complaining about how much information she had. She's like, there's so much. I can't possibly be ready this year. There's so much stuff to go through. I need loads and loads of time. Plus, I need more information. Okay, so she's complaining about how much there is and says she wants more. But at the same time, she says, but I want the more information to have a deadline so it stops. Okay, I can't really tell you how long it will take me to prepare until I know when all the information is going to stop coming in. So we're going to discuss that on the 28th, and that's the discovery cutoff deadline. Oh, my computer just told me it's Valentine's Day tomorrow, and I remembered without its help. I'm proud of myself. So we're going to discuss that. In addition to the change of venue, the discovery cutoff deadline, that's when everything has to be handed over to defense by that time. Expert disclosure deadlines, there's, who's going to have what experts. Deadlines for filing any pretrial motions, such as motions to suppress or motions in limine. Okay, there will be motions to suppress and motions in limine on this, but the 28th isn't the deadline. They're going to set a deadline saying by this date, this is when we're going to be able to file all our motions initially to say this is what we think should not be allowed in. And defense is going to have a lot of those. And some of them will be absurd. I'll just call it right now. But they're going to basically say everything is too prejudicial, like the DNA evidence on the sheath of the knife. It's too prejudicial, Judge. We'd like to exclude that. Probably not going to happen. All right. Anyway, so all that's going to happen. That's going to happen on the 28th. So yay for that. We're excited. We'll have that on the calendar as well. Today, because of the weather and other things, there is not much happening in court. I realize that one case, which is terribly tragic and sad, which is the Adam Montgomery trial, which Justice for Harmony is going on today. That's pretty much the only big trial that's happening. So we're going to be doing some court hopping today, possibly if they let us, if they do it. We might do some
break for lunch, Judge.
Some Louisiana parole board hearings. Paula Mac, I can't find the certificate. I never downloaded one. Okay, well, I'll see if I can get you the link to the certificate. Or maybe one of my mods could do that if you're able to pull that up. All right, Robert Hamilton, happy birthday, 37. That is awesome. All right, where are... Let's see. It's Selma's Day today. It's a delicious Swedish... Selma's Day is a Swedish... pastry.
Are we going to address subject matter jurisdiction?
Did you bring enough for the class, Angela? Can you share? I've never had Selma's Day. What is it made out of? I mean, I realize pastry, but it must be good. Most of the Swedish pastries, I think, are. Scandinavia in general just does it right when it comes to that. All right, any new cases coming up? Yes and no. You found it, says Paul Mack. Good. Can we relook at the cell phone ping thing in BK, given what we learned yesterday regarding accuracy? When all that information comes out in trial, I want to see it in trial because I'm not sure if they've had a chance to go over everything yet. But I hope that whoever does the testimony in trial in the BK case uses the presentation that we saw in Judge Wolf's court case yesterday. It's Semla. Did I say Selma? Not Selma. I said Selma. It's Semla. That probably makes a difference when I'm Googling. Free pancakes at IHOP today, says Renee. Everybody, quick. Mass exodus. Let's see. Significant weather is over here in New Mexico. Got a morning of snow on Saturday. It's almost all melted already. I saw in the whole world is just crazy weather right now. We've got Turkey is like massive flooding in some parts of Turkey. We've got the cliffs collapsing in California, and many multi-million dollar homes are about to tumble into the ocean, quite literally. We've got snow up north. That's why the Trachonis trial is not happening today because of the snow that came in. Meanwhile, I'm sitting here at what's our temperature? It was like 70 degrees yesterday. Today it's thinking 54, but it's going to get up to 63. So not bad. A little windy, a little bit of rain overnight. Woo, 2 months and still love to be here. P.S. Did you find your little song on Facebook? Allie Lane, I have found a bunch, if this is what you're talking about, I found a whole bunch of emails and messages of people who have rewritten the song for Sarah Boone to Henry VIII for her 8th lawyer celebration. So much creativity. I looked at it so much, as I was reading along the songs, I was trying to play the song in my head, and I forgot how Henry VIII went. And so I'm like singing it to other tunes, which didn't work as well. But it was really, really fun. Let's see. It's spring, almost summer weather in Serbia and southern Europe, says Angela. Great weather. We've got dandelions in the front yard, which means it's wintertime for us. Can we get Mrs. Ray to bake us some cinnamon rolls? I want Dr. Joe's cinnamon rolls. His wife at that store, oh my goodness. It is so good. It is so good. For those that didn't catch it, Dr. Joe was on last night with Yoli and Paul, juror number 1 and wife. Great little show last night. Got to catch part of it. It's raining heavily in Northumberland. Also, happy Pancake Day to all UK in chat. Something about the way Bug Dugger is lurking makes it a little creepy. All right, it was a great interview yesterday. Thanks, Michelle Mixed Media Madness, for being there as well. Dandelions means spring here in the UK. All right, let's do this. We have some court cases to find, and I realize it's only 9 o'clock, so we're limited as far as who is up and open. Let me do a quick check. I Rescue Dogs. Wow, a year already. Thanks for the great community. I Rescue Dogs, thank you so much for being here. I appreciate you being here. Wouldn't be the same without you. 12 months. That makes a whole year by my math. That is super exciting. Thank you for being a great part of this community. All right, we have possibly Judge Simpson might be doing something soon, but not yet. Let's see. Judge Simmons. Let's see what Judge Simmons has going on.
I don't think it's not being recorded. Be on video. That is true.
Lots of people in the courtroom, but I think they're just getting ready to get started.
Wayne, am I all set? Wayne, can you hear me? They don't want to hear you. She can hear you, Michelle. Okay, but you can hear them. Not them to hear you. You don't have to speak whatsoever. Okay. You're defensive. You don't speak now. Just sit there.
You're not supposed to speak. Just sit there.
Stay with me, Carl. Stay with...
Michelle, just to let you know, we're waiting for the judge to return to the bench.
Thank you.
Stay with me, Carl. Stay with me. Mr. Farag, to my knowledge, has not been captured. He's still on the lam. I don't think she would be the defendant. I don't think Michelle's the defendant if she can't figure out Zoom and is the only one remote. Witchy Mama says, this is the first time ever I've seen no snow in western Minnesota for the winter. I'm not complaining, though. Could be a bad summer, though, if there's no snow. Oh, judge is in. Everyone quiet.
Okay, you can be seated. My understanding is that she can hear us now. Ms. Lundgren, can you hear us?
Yes, I can.
Okay, we can't hear her, but I don't see a problem with that because we don't want her to say anything on the record when our attorney's not right there. So that's perfect. We can proceed back on the record. We've already had appearances. We have a couple of motions that need to be addressed. I'm going to first address Defendant Kit Vanderwood's motion to allow third-party stenographer to attend and transcribe the preliminary examinations. And I did not receive a response from the Attorney General's office. Did they seek any objection? No objection to that? Okay, I'll sign that order. And I believe the stenographer is already present. Is that correct? Oh, yes.
Your Honor, if I may?
Yes.
I think there's one open issue on the court reporter transcript, and that is how it can be used afterwards. So it's great that we have a court reporter here. I think there's some purposes. We'll see what's on the transcript closer in time to today's hearing. However, if there's going to be motion practice, which I'm sure there will be, at least for bind over, and I'm not sure the court's timing on that, whether that will be at the end of this group session or at the end of when all defendants have had their exams. But it seems to me that we should be able to use the transcripts that get generated for today and tomorrow for purposes of motion practice down the line.
Those transcripts will not be used for motion practice. You need the official court record if you want to do motion practice. And if you want to request an expedited court record transcript and the expedited rate, you can do that. But
this might be interesting.
Bringing his own personal stenographer does not substitute the use of a official court record to be filed with yours. Any motions.
The court appears to be packed.
I'm just allowing him
got
to bring
multiple
a
cameramen
stenographer
there.
to transcribe. My assumption is they want to use that
Anybody know what this is
for
about?
the purposes of preparing for their own preliminary examination.
Thank you.
Thank you. There was also a people's motion to quash subpoena or issue a protective order. That was received by the court at 3:30 yesterday.
That is not set for argument today, Your Honor, and the parties are in absolute agreement that the parameters of that can be worked out later. So we ask the court for purposes of today to disregard that.
Very good. And I think that that was mentioned in the motion, considering the fact that the defense is not likely to be calling any witnesses today.
Correct.
Or tomorrow.
And the only reason we filed it yesterday was because it would have been due by the 14th. And so any later it would have been untimely.
Thank you.
Thank you.
There's also the people's motion for Assistant Attorney General Aaron Van Langeveld. Is that how you say his last name?
Yes, Your Honor.
To remain in the courtroom during the preliminary examination. I received that filing. I did not receive any responsive filings from the defense counsel. I see someone pop up, so I guess you want to respond on the record.
Yes, Your Honor. First, can I have a continuing permission to step into the lower courtroom and put my stuff up here? I don't want to do anything.
Put your stuff where?
On this bar here.
As long as it doesn't interfere with what he's got to do, I can't see it anyway. So
thank you, Judge.
And Your Honor, Ms. Burden did file a response to our motion, so the people did receive that. It was absolutely timely. We've had an opportunity to review it. However, I don't believe any of the other defendants have filed an answer to our motion.
Mr. Burden file a judge's copy.
I believe so, Your Honor, but I have a copy here. I mean, I don't expect the court to read it on the bench, but I'm happy to provide it.
Yep, you can make your argument now.
If I may approach.
Thank you.
Thank you. And with it being the people's motion, we would ask to make argument prior to Ms. Burden.
Yes, that's completely fine. You may proceed.
Very good. Thank you, Your Honor. So the first thing I want to do, and acknowledging that the court is at this time reading Ms. Burden's response, there is something that I want to absolutely address from that response at the outset. So the people's motion asking for their attorney to remain in the courtroom is not, as Ms. Burden has argued, and perhaps others will argue today, a motion for reconsideration or rehearing under MCR 2.119F. That court rule deals with, and I quote, rehearing or reconsideration of the decision on a motion. It appears within the rule that governs motion practice. The defendants here did not file a motion regarding A.G. Van Langeveld's situation. Instead, they made an objection. And it was, in fact, the defendants who had control of exactly how this issue would come before the court. And they decided in a manner that appeared, at least to the people, rather coordinated, to object during the preliminary examination rather than file a motion and brief and seek an order ahead of time. So because the defendants did raise this matter as an objection, it's really no different than any other ruling made during the course of a single proceeding, which this court may, of course, correct as new information comes to light and reconsider as the proofs roll in. And we are still here today, Your Honor, in the very same proceeding where that objection was initially made. And that is why it is MCR 6.435 that controls, and the court may reconsider that ruling just as any other evidentiary ruling that's made in this proceeding. And this isn't even the first time that this has happened. On December 13th and December 14th, this court was asked on many occasions occasions to reconsider previous rulings depending on what the testimony was. And it is no different here. The court is allowed to reconsider an objection that is made within that very same proceeding. And that is what is occurring here today. Now, as to the substance of the motion itself, Your Honor, the people's motion places one matter and one matter alone before this court, and that is whether MRE 615 prohibits sequestering the people's representative, AAG Van Langeveld. MRE 615 is titled Exclusion of Witnesses, and it puts exclusion of witnesses within
They're arguing to keep an
an
attorney out of the courtroom. With the exception of three categories, because he's also
two of which are at issue here and are applicable to all assistant attorney generals who represent the people in this matter as designated by Attorney General Dana Nessel. So first, under Section B, the court cannot exclude an officer or employee of a party which is not a natural person designated as its representative by its attorney. MCR 6.0031 defines party to include the lawyer representing the party. And that is critical for how this component of the rule is interpreted and applied to AAG Van Langeveld. So there are really three parts to that component, Your Honor. And this isn't a hocus pocus thing where we're trying to twist the language of a rule or anything of that nature. We want the court to look at the language of this component and consider how it applies to the people's representative. So first, the party at issue here is the people of the state of Michigan. And collectively as a party, the people of the state of Michigan is not a natural person. And no one can dispute that. We are not a natural person. We represent the people of the state of Michigan, not a single individual.
This is an election.
Second, the people of the state of Michigan's attorney in this matter is Attorney General Dana Nessel. And again, no one can dispute that. She is the attorney. Third and last, AAG Van Langeveld is one of the Attorney General's employees or officers. Both of those are true. And she has designated him as one of her representatives in this matter. And again, because party is defined as the court rule as including the lawyer representing the party, there is really no dispute that AAG Van Langeveld cannot be sequestered under Section D of MRE 615. Second, MRE 615C prohibits sequestering AAG Van Langeveld. The court cannot exclude a person who is shown by a party to be essential for the presentation of a party's cause. And of course, it is only a party, whether that is the defense or prosecution, who can decide who is essential for the presentation of their cause. It is not for the other party to weigh in on that inquiry from a factual or even a necessity standpoint. But what I am saying to the court today, as an officer of the court and as a representative for the people, I'm affirmatively stating for this court that there are 4 lawyers from the Department of Attorney General who are assigned to this case as the people's representatives, and each of them are essential to the presentation of the people's cause. AAG Van Langeveld is essential because of his role in the investigation, his familiarity with the case, and his expertise in election law. Because of his expertise, he's uniquely situated to consult with the rest of the team regarding issues of election law as they arise during the testimony. He is absolutely essential from a factual and a strategic standpoint. And while I appreciate, I guess, the implied compliment in Ms. Burton's response that there are 3 talented lawyers who are currently representing the people in this matter, I agree, there are 3 talented lawyers. It is not, the inquiry is not whether we need a 4th. We are not each fungible substitutes for one another, and we each have our own unique roles and skills in this matter. And the inquiry is not also whether the remaining AAGs on the team can consult with a witness or find someone to ask their questions later. We need AAG Van Langeveld in the courtroom to assist us in real time as these issues arise. His absence has already harmed people's ability to present their cause, and we're asking this court to correct that today because MRE 615C prohibits his sequestration. Now, as I said earlier, the only motion before the court today deals with MRE 615. However, when we were last here, there appeared to be some sort of implication from the defense that there was something unethical about AAG Van Langeveld serving as a member of the prosecution team while also being a possible witness. And that is absolutely incorrect. And it is not a part of the inquiry under MRE 615. I know the court is still reading Ms. Burden's response. She really doubled down on this, and I don't know if we're going to see that type of argument from the rest of the defendants today, but in doing so, the problem is that she ignored the actual language of Michigan Rules of Professional Conduct 3.7 and ignored the definitions that actually apply to that inquiry as well. She substituted her own definitions, and that's just not how this works. Of course, AAG Van Langeveld is an advocate in this case in the most general sense. And of course, he is also an assistant attorney general, but those are not substitutes for definitions that actually apply. Under MRPC 3.7a, a lawyer shall not act as an advocate at trial in which the lawyer is likely to be a necessary witness, except where the testimony pertains to an uncontested matter. So just a couple points about that, and then I promise I will sit down. First, we're not at trial yet. Second, it is not just being an advocate, but being an advocate at trial that matters. We are not at trial yet. Being an advocate at trial, according to State Bar Ethics Opinion RI 281, means presenting evidence or argument in a court. So from an ethical standpoint, because Van Langeveld is not an advocate at trial at present, and he never will be an advocate at trial, it doesn't even matter what kind of witness he is. He could be a necessary witness. He could be a necessary witness regarding contested matters. He could be a witness. He could be someone who was subpoenaed for any reason or no reason at all, because it doesn't matter what type of witness he is. He's not an advocate at trial, so it doesn't matter what kind of witness he is, Your Honor. He could be any of those three categories. He could be the most necessary witness on the most contested matter, but because he is not an advocate at trial in this matter, there is no ethical problem with him being on this team. And I know that that's something that the court is familiar with from your experience as an assistant attorney general. You're familiar with the process internally that occurs, the inquiries that occur, and we did share that with the court just for the purpose of being transparent about what our inquiry is. So, serving AAG Van Langeveld with a subpoena doesn't matter for purposes of MRE 615 because it doesn't matter what kind of witness
Jenna
he
Gardner,
is.
I
He
think
will
that's in
never be
April,
an advocate
Robin.
at trial, so he can ethically be any type of witness at all. So for these reasons, we are asking the court to find under MRE 615B that AAG Van Langeveld cannot be sequestered. He is a representative of the people in this matter, and he is also essential to the presentation of the people's cause, so he cannot be sequestered under MRE 615C. Does the court have any questions about our position? I'm also happy to address anything that the court has been thinking about regarding this, or any concerns that the court has.
So it's not the position of the Assistant Attorney General or the Attorney General's office that this advocate or attorney is not a potential witness. You're not.
Absolutely not, Your Honor. We agree and concede that he is a possible witness. But the thing about MRE 615 is that it assumes that who we're talking about is witnesses. So it's not, it's not a rule that applies if he wasn't a witness, for example. Yes, we agree that he is a possible witness. Now, as we discussed earlier, there is a motion to quash his subpoena pending, but even with that, we're not saying he couldn't ever be a witness for anything. We're just saying the things that were identified as potential topics of testimony are not appropriate. There's no doubt that he was involved in various aspects of the investigation. Those are potential topics of inquiry for
just waiting for a
him
ruling
as a
on this
witness.
one. We might bail
And,
in just a minute.
we're also not contesting what his role was on State Board of Canvassers. He is a possible fact witness for those things, just not in the manner that was identified in the answer that was filed by Ms. Burden. So the court is completely correct. The crux of this is that he's not an advocate at trial. So he can be a witness. And these are no different than the rules that apply to civil attorneys as well. This is an inquiry that comes up, I think, a lot more often when we're talking about potential civil clients. And, that's really where the ethics rule, the ethics opinion rather, RI 281 comes from. It was a case dealing with, what the parameters of a civil attorney could be when they're also a possible witness to a situation. And so, this isn't even an inquiry that is limited to prosecutors. It's something that comes up quite a bit with civil attorneys as well. And they have to examine ethically whether they can be a part of a particular case and what role they can serve in it. So it's not really irregular here or in the civil realm. Attorneys, whether anybody likes it or not, attorneys can serve dual roles as witnesses and attorneys. It's just that their role has to be carefully crafted, which is what the people did here. So long answer to the court's question, but no, we're not contesting that he's potentially a witness.
Thank you, Mr. Kroger.
It was a long answer for no.
Thank you, Judge. My strategy here has changed a little bit because I guess due to our failure, the court didn't receive the judge's copy. So if the court would bear with me, that was a lot to address. I had hoped to largely rely on my brief. Number one, I would say that there's no question that what is in fact an improperly submitted motion for reconsideration. It's not our job as defense lawyers to telegraph our movements, to ensure that the prosecutor's evidence passes muster that they present in court. The court will recall that the prosecutor submitted for admission a document bearing AAG Langeveld's signature, which is the topic at issue in this case. The objection was made, and the people then made an oral motion. The court heard argument from the prosecutor, and then it heard argument from the defense lawyers, and it made its ruling. So consistent with the rule for motion for reconsideration, an oral motion is a motion. They happen all the time. That's what the people did. They blew its deadline. It should be outright denied as untimely. As it relates to—
That's a good argument.
Advocates.
So what's happening is the state wants to include a lawyer, allow them to stay in the courtroom during a trial. The previous judge ruled that he has to be excluded like the rest of the witnesses.
But I have to point out, so the court isn't, one's not pulled over the court's eyes here. In its principal brief, the state labeled AAG Van Langeveld as a consultant and a representative, saying therefore that he's outside Rule 615's, he's included in 615's ability to be included in court, even though he's a witness. In the brief that they filed yesterday, the court said at 3:30, and I'm not faulting the prosecutor. I anticipated a motion sort of like what they filed. I'm not faulting the timing, but I do have to highlight for the court that by nature of the subpoena, AAG Van Langeveld morphed from consultant and advocate back to prosecutor in yesterday's brief. I know the court hasn't had time to read it. So there's no question that he is in fact acting as an assistant attorney general prosecutor in this case. It's not a political consultant. It's not a representative. In fact, the court will recall we stipulated Agent Schock being the representative, which is commonly understood that the lead investigator or detective or officer in a case for prosecution gets to stay in the courtroom. That everybody knows that. We don't dispute that. The representative has already been assigned. when it comes to essential, Your Honor, actually, let me back to 615B. 615B says that the designee is assigned by an attorney, the attorney, which necessarily excludes from being a representative under 615 attorneys. As it relates to being essential, the prosecutor stated that 4 prosecutors are essential to this case. AG Crino, AG Logan, AG Van Langeveld, AG Hageman Clark. I'll note that AG Hageman Clark is so essential, she's not in court. I think the same goes for AG Van Langeveld when it goes to who's essential. The real prosecutors prosecuting the case are at the prosecutor's table, Your Honor.
Okay, sit down.
AAG or the prosecutors cited and referenced a ethics opinion that they attached to their principal brief, Your Honor. And I have to note that that opinion, number one, is redacted. I typically wouldn't go after such an opinion in discovery. The people who put it in issue, it's attached to a brief. It's redacted. It deals central to the issue that they're raising. It's my position that the defense is entitled to discovery on that ethics opinion. They need to be ordered to reveal who wrote it. All of the discussions among the Attorney General's office are no longer privileged, is our position. We'll brief this more fully for the court in our response to the motion to quash. Just flagging it for now. And I also have to note the ethics opinion says, number one, my read of it, obviously we can all read it for ourselves. My read of it is, number one, AG Van Langeveld can theoretically participate in the investigation. However, he cannot participate in the prosecution. Well, this is the prosecution, Your Honor. And in fact, the state has labeled him a prosecutor in the most recent pleading. The people today declared, yes, he's an advocate, yes, he's a prosecutor, so on and so forth. They're trying to shield themselves behind the prosecutor's immunity and the safeguards that would prevent generally a prosecutor from being subpoenaed. I have to state, if you give a fair read to the people's pleadings, Your Honor, it is pretty clear that the people of the state of Michigan, through the Attorney General's office, are attempting to further violate their own ethics opinion. That needs to be explored. It's, again, attached to the brief. It's in the pleadings. And I don't know what the remedy for something like that is. I don't think anyone, and I know I certainly have never seen anything like this in a criminal prosecution. Step number one, criminal prosecution. Everyone will tell you, don't make yourself a witness in your own case. Why they did this, I think briefing and argument testimony is going to bear that out, but it's a major problem. And I don't mean to throw, and I'm not trying to throw allegations out unfounded, but there's an inquiry might need to be made about prosecutorial misconduct and what it means for this case.
Ooh, throwing out the big words. Basically, pointing the finger of blame at the other side.
Okay, well, I just have a question since you paused it.
Yeah, sure.
Because your office subpoenaed this witness, correct?
Yes, sure.
Okay, and so can you really just touch on why this witness would be a necessary witness?
Yeah, sure. So it's well established that AG Van Langeveld signed the documents that he signed and engaged in the activity that he did as a member of the State Board of Canvassers. Is very public. Politico article references him as the lone man that stopped Trump. I think the evidence is going to bear out that Special Agent Schock's, I would say, very unusual affidavit with many legal theories and case law citations, I believe, so on and so forth. The entire justification for charging this case was that there was no viable, plausible legal argument that could result in reversal of the official votes. Now, I'm not here to relitigate 2020's election, whatever. We should move on beyond, that piece of it. But the fact of the matter remains, on December 6th, and this is going to come out too, AAG Van Langeveld, AAG Carino, and Special Agent Schock sat down with a man named Ken Chesbrough, who explained to them for over 4 hours how multiple, not just a recount in Michigan, multiple avenues existed based on federal precedent, based on historical precedent, based on statutes in the federal code, the U.S. Constitution, so on and so forth, that there was in fact the possibility that it could have been reversed up to January 6th. Again, I'm not saying one way or the other what the merits of that happening were, what the practical possibilities or probabilities were, but at base, what it comes down to is AAG Van Langeveld put the very legal reason in Agent Schock's, at least that's my theory, affidavit to justify getting this through, so warrants would be issued. And then
we're just going to stick with this until they rule
testify,
on whether
and again, we'll address in
lawyer
writing
gets kicked out or not.
The people's motion to quash or protective order. When he testifies, it's going to come up. What did he think? He being Van Langeveld, who effectively argued with Chesbrough in the interview that, the margin was so big, there wasn't a recount, therefore there was a crime committed, basically is the gist, and that's what's going to come out. Did Van Langeveld, ultimately where we're going to go, but it'll be in more detail in our briefing, did Van Langeveld understand at the time that he was sitting on the board of state canvassers that if the court reported back to him, hey, you got to recertify the election in favor of then President Trump, does he understand that he would have had to sign that, so on and so forth? That's ultimately where we're going. It's not as clear as, oh, he just signed this paper and, that's his only role in the case. The other piece of this that the people have really opened up, and I think it's a very unusual hill to die on, why he joined the prosecution, given his very public national attention as it related to Michigan's election, why he joined the prosecution to come after these people. I mean, prosecute grandmas, widows, and grandpas for something that's frankly not a crime. We'll get to that in our briefing as well. That all goes to credibility, not just of AAG Van Langeveld, but of the entire investigative body. The motivations for prosecuting this case, it all ties together. It's all exculpatory, is my view, potentially exculpatory. And the defense is absolutely entitled to all that information. Moreover, the Michigan Rule of Evidence 615 that the state is attempting to rely on gives way to these criminal defendants' statutory and constitutional rights. So to narrow in on a Michigan Rule of Evidence and say, oh, fairness goes out the window, oh, Sixth Amendment to right to confrontation goes out the window, and so does everything every prosecutor who's ever prosecuted knows about prosecution goes out the window, because the Michigan Attorney General wants to prosecute these people for something that's political and not a crime, Your Honor, is not constitutional, it's not lawful. Did I answer the court's question? I apologize. I ranted quite a bit.
We went off on a large tangent there, but I think you hit it in the beginning. Any further argument that you wanted to provide?
If I may have one moment, Your Honor.
Yes.
I want the judge to rule on this. We're going to look for something else. Don't whisper right into the mic, because they can hear you.
Good point for my colleague, Your Honor. This is, the people referenced the civil case. This isn't a civil case. This is a criminal prosecution with a maximum penalty, in theory, of up to 14 years in prison. The defendant's, Kathy Burton's liberty is online. We're not talking about money here. That makes this case very different. So to say, well, this happens in a civil context all the time, I mean, maybe not. I don't think any lawyer is putting themselves in a position intentionally where they're going to be a witness in their own case. But even if it were happening in the civil context, Your Honor, it doesn't apply to the criminal context. It's a totally different thing. Every court in Michigan, the U.S. Supreme Court, Sixth Circuit, federal districts, everybody recognizes there's far more care and rigidity in criminal prosecution than there is in a civil prosecution.
You should go to the bathroom.
Did she go to the
The
bathroom?
other thing to consider is improper vouching. Sequestration is important. He's a fact witness who it's the defense's belief that basically orchestrated the entire erroneous, in my view, legal theory of how this case was even brought. His comments to Mr. Chesborough, I think I'm saying that right, really bear that out. He's I think the orchestration of this entire thing. I think he explained it to Agent Schock, and ultimately, when the Attorney General gave her comments publicly, what she was saying is the same thing he's saying. So I think the defense is absolutely entitled to explore that with him on the witness stand and get to the bottom of where did this idea come from? How did you get here, given the political nature, your involvement in the case, so on and so forth? He was the lead investigator.
Okay, and you're addressing the motion of quash, is that what you're addressing?
Yes, sure.
Okay. Oh, okay.
No. I'm
Because you're getting into what you want to question him about.
Oh, well, it goes to vouching. Okay. Yeah, sure. So keeping him sequestered goes to vouching. Okay. It protects from improper vouching is the point.
Okay, and I recognize that, but I want you to address also the rule of evidence, 615B, that states, and again, this is about witnesses. So that rule essentially states that witnesses can't be excluded if they're designated as the representative by its attorney. So I need you to address that.
By its attorney, Your Honor?
Correct.
He is an attorney.
So attorneys can't have attorneys?
Not when they're not a party to the case.
Okay.
Absolutely. And the other, so it is addressed, Your Honor. Agent Schock is the designee. How many designees does the state get? Can all 300 AAGs come in here? I would say no. We stipulated that's the designee. What they have done is after the fact, after it was exposed that their prosecutor is improperly involved in this case, and he was thrown out of court, they are sequestered. They come back with new ideas as to why he should be here. And frankly, Your Honor, I think it's an ego thing. It's not based in law. The law here that controls is ultimately the defense's right to fairness, justice, Sixth Amendment confrontation, which includes a fair chance of cross-examination. That's the theme underlying sequestration.
I completely recognize that, which is why I granted the sequestration order from the beginning. But if we identify and we break down this rule that's been presented here on the people's motion, you got to understand that it states that they can designate him as their representative, correct?
I just wanted to rule on this so we can move on.
I disagree with that.
The party can't designate him as a representative because what in this rule tells you who they can or cannot designate as a representative?
The word attorney, Your Honor, necessarily excludes.
It says the party's attorney.
He's a prosecutor, Your Honor.
He's not a prosecutor on this matter.
I can show you the briefing, Your Honor. Yes, he is.
Which briefing?
The one that they filed yesterday.
I've not looked at the briefing yet. So that's not at this time before the
well,
court.
then I would ask that.
But is he filed? Is he entered an appearance on this case as the prosecutor?
I think he did when we all stated our appearances on the record. And again, I don't have that transcript, but I believe he did stand up and indicate his appearance as an assistant attorney general on behalf of the people.
Counsel?
I can help here. It doesn't matter one bit. Yes, he is a prosecutor. Yes, he is a consultant. Yes, he is an advocate. Yes, he is an assistant attorney general.
Well, how can he be the advocate and the attorney?
Well, advocate at trial is defined as someone who presents argument or evidence at trial. So that is a definition that we only care about if we're talking about the ethical inquiry under 3.7, which obviously is not before the court.
Correct.
I already broke down each piece of MRE 615B. And the thing that is really key for how that applies to attorneys is that it doesn't matter that we're all prosecutors. We are still lawyers, and that rule applies to us the same way that it would as anyone else. And the definition that I previously gave for the court under MCR 6.0031 of the definition of party, including the party's attorney. So we are all, as prosecutors, only here at the pleasure of the Attorney General of Michigan. She is the attorney. She is the attorney for the party. She is the representative, and she has designated all of us. So,
but you are the prosecutor on this case.
What does the court mean when the court is asking that question? Because I feel like maybe we're creating.
You're in the court prosecuting the case. Your name is on the pleadings. When you work as an assistant attorney general, that power is vested to you to prosecute the case.
100%.
So you are vested today to prosecute this case. My question is he prosecuting the case as well?
No.
So that was the question, because did he file an appearance on behalf of the people?
That is correct.
And I can go and check the record to see if it's
hold on.
I'm sorry. Well, the guy was sitting there then. The guy that was sitting there at the time.
Yes.
That Van Langeveld, that I excluded or sequestered under the sequestration order. And there was another lady that was here as well.
Yes, Ms. Hageman Clark. That's correct.
And so they both, I recall, put an appearance on the record when I asked for the prosecution's appearance.
Yes, that's 100% correct. We agree with that. They are all four prosecutors on this case.
Okay, so then my concern then is how can you be a prosecutor in one regard, which means you can stand and place an objection if you'd like, you can file pleas if you like, but then in the next regard, you become an advocate if it means that you can stay in the courtroom for sequestration.
No, he cannot and is not going to be an advocate at trial, and that's a decision that was made very early on. That doesn't mean that he can't serve as a consultant. That doesn't mean that he can't assist me if I have a question about Michigan election law that requires the expert who's assigned to our team to help me with. That doesn't mean that I cannot ask him a question. That does not mean that he can't be part of things behind the scenes. So the problem with the way that this argument is going so far is that we are blending three things that really should not be blended and cannot be blended in order to reach the correct conclusion.
Well, in order for him to stay in here under this court rule, he has to, or this rule of evidence, he has to be designated as a representative. So I'm trying to understand what category you all put him in, because it's switching.
No, Your Honor, it's not switching. It's all of these things at the same time. Okay, I have never been inconsistent. It is all of these.
That's a problem, though.
Well, it is not a problem under the court rule, Your Honor. Under MCR 6.
I think it is.
15B.
I think it is a problem.
There is nothing that says that he can't be an attorney and a representative at the same time. I am an attorney and a representative at the same time.
Specifically, the officer or employee of a party that is not a natural person after being designated by the party's representative by its attorney, which means that its attorney, the party, you would need to be the party's attorney, which you are on this case. And you designated him as your representative.
I am only an attorney on this case as designated by Attorney General Nessel. So she is the attorney for the people of the state of Michigan on every criminal case that the Attorney General's office appears on. Okay?
I recognize that.
I, Ms. Logan, Ms. Hageman Clark, Mr. Van Langeveld, we are all employees or officers of a party as defined by the court rule. So I'm not making up my own language of this or anything. This is what the court rule says. So Attorney General Nessel is the attorney. We are her party. We are her officers or employees, and we have been designated as her representatives in this case, Your Honor. So that is our position. I respect if the court disagrees with that, but I think it really is important for that component of it to remember that party is defined as the attorney representing the party, and that is Attorney General Nessel. And
by and through you.
I'm sorry?
By and through the parties that are here. So
yes,
you are
because
prosecuting, because we're not going to see Dana Nessel in here on this case. We're going to see the people that are sitting here filing the pleadings, appearing at the court cases, and making the argument.
Yes,
correct?
The court is absolutely.
Any other argument?
I need to correct two things. Number one, the party is not Dana Nessel. The party is the people of the state of Michigan, Your Honor. Number two, the people just said, they redefined 3.7 and said that AAG Langeveld is fine as long as he's not presenting an evidence at trial. No, the definition she said the first go around was presenting evidence in court. The entire reason
we don't even need to address that because we're not dealing with that right now. And they also said that they decided he's not going to be an advocate.
He's not an advocate at trial. That's the
an advocate at trial. And we're not even addressing that. I'm addressing 615B. That's all.
Can I just
only if it addresses 615B.
So it does. He is an attorney and advocate at under 615 because he's feeding information she just said to her to make. She might not be the one saying it, but he's speaking through the rest of his co-counsel, which have second chairs in trials happen all the time. That person, if you're only been a lawyer 2 or 3 years, doesn't talk. They say, hey, ask him this. Hey, do this. It's happened in this court.
Your Honor, that has nothing to do with MRE 615B.
Through the mouthpiece.
Nothing.
I'd invite the rest to join in.
Really briefly, Mr. Van Langerveld's role has morphed and continues to morph today. So he has 3 roles as I counted them today. An attorney, and he stood up and put his name on the record the last time we were here. A witness, and he is a fact witness, a material fact witness. And then now, today, a representative. It appears he was designated as a representative after the fact in order to get him in the courtroom. Those 3 categories are they are mutually exclusive. So under 615B, an officer or employee of a party, Mr. Van Langerveld is not an officer of the people of the state of Michigan. And I don't even think he's an employee of the people of the state of Michigan. He's an employee of the Attorney General's office. After being designated as the party's representative by its attorney. You can't be both an attorney and a representative and a witness all at the same time. I mean, if we think about this in the most basic of context, if the prosecution has a murder here and then Mr. Langerveld is a witness to that murder, is he going to prosecute at the exam and then pop up and then provide his testimony? It's gamesmanship, and I'm not even sure why it is a fight that the Attorney General's office wants to have. Every minute that he would be in this courtroom diminishes his credibility as a witness for the government. So I join in the comments and the objections by Mr. Koger and Mr. Danini, and he should not be in this courtroom.
Thank you. I'm done taking argument on this issue because it's almost 10 o'clock and we've not proceeded on this exam. I read the briefs except for the response from Bearden, but you've given your arguments on the record. I agree that Mr. say his name again?
Van Langerveld.
Van Langerveld's role keeps switching at the convenience of the people. And I have a problem with it. I think it's grossly prejudicial to the case to have this person who is, I believe, a essential witness. He was on the board of canvassers. He's the person that helped vote to certify this election, which is the issue at stake here. And he's sitting here. He's obviously been a part of the investigation, and that was up to the prosecution to decide if they wanted to include him on that after they've gotten their ethics report. The ethics report even tells you, I don't see a problem with him being a part of the investigation, but there could be an issue with him being a part of at the time of trial. I think that he needs to be sequestered. I think the sequestration ruling was appropriate. I think that to use the defense counsel's word, this is some gamemanship by the part of the Attorney General's office, because we can't have a role switching and we can't have all 3 roles. You're not going to be an advocate when it's appropriate. You're not going to be a representative of the Attorney General when it's appropriate. And you're not going to be an essential witness, all at the same time. And so, and I think that the Attorney General's office perceived this to be an issue in advance, and things have been switching at the convenience in order to try to figure out how to get him in here. My sequestration ruling stands. I'm going to deny the motion to quash the subpoena because I think he's an essential witness. They have every right to call an essential witness to submit to their defense. I also agree that you wouldn't want to have a witness in here that could take away from your credibility. And I get that he may provide some valuable information and knowledge as it relates to election because of the nature of the background that he has. He sat on the board of canvassers. So I recognize, again, as Mr. Kroger put in at the time of his motion, I too worked at the Office of the Attorney General. I was in civil litigation, employment, and elections. So I understand that there's certain individuals in that department that have a specific knowledge base that could assist in this case. It's unfortunate that the Attorney General chose this person to be a part of the team, understanding that there could be an issue as it proceeds or as it progressed in the courts. At this point, that's something they're going to have to live with because my ruling is going to stand. So any additional matters that we need to address before we call the next witness?
Thank you, Your Honor. Nothing on that.
Thank you, Your Honor.
Okay.
This could be
So we're going to turn that off. That's as far as we're going to go. We rode that horse as long as we wanted to. So that whole argument, all that spicy argument on both sides, the discussion, this is pre-trial, and it's an election issue. It's an election fraud issue from 2020 and in Michigan. The whole argument was whether or not the state can have one of their essential witnesses who was involved in the what went on, also as a lawyer and an advocate, if he could play all the roles and get around the sequestration rule, which keeps him out of the courtroom while other testimony is being given. That was it. And you can tell how spicy the argument was. This is arguing over whether a guy could sit in the courtroom or not during the trial. Wow. Judge says no. You can't wear all the hats. So we have another one I have not watched before. This is Judge Lisa Babcock's daily docket, and I'm gonna see if we can just jump in here and pick up what's happened this morning. We're just a couple minutes behind on her feed, but let me see what's happening here. This is started about 10 minutes ago. Good morning, Krista. 2 months to go, and I'm orange.
I do not have a fingerprint order for this one, should I?
Your Honor, we will get that going for you.
Okay, thank you. All right, so good morning.
Good morning.
We are on the record in the matter of People versus Finley McNeil Gleason. This is case 24-0037 SD. May I have appearances for the record, please?
Yes, Your Honor. Melissa Vachon on behalf of Mr. Gleason while he appears separately by video.
Thank you.
Dressed
And
appropriately for
Mr.
court,
Gleason,
I might
could you
add.
state your name for the record, sir?
Hi, Finley McNeil Gleason.
Okay, thank you. So we are here today for an arraignment, sir, and I call arraignments the worst case scenario hearing. Here's why. I'm going to read the charges against you with the maximum possible penalties, and you aren't going to be allowed to say anything. There's a reason for that. You are innocent in the eyes of the law, and the court is not going to let you say anything that could come back to haunt you later. I assure you, Attorney Vachon is certainly not going to let you say anything that could come back to haunt you later. So that's why we don't let you speak. It's not to be disrespectful or because the case is decided. It's not. It's to protect your innocence. The second thing is we have this hearing because you have a constitutional right, Sixth Amendment, if you're taking notes, you have a constitutional right to know the charges against you so you can defend yourself. You can't really defend yourself unless you know what you're accused of, right? So that's why we have this hearing. It's not to waste your time or make you feel bad. It's because you have this right. So we're going to do 5 things this morning. I'm going to read the charges against you, the maximum possible penalties. We're going to talk more about your rights. Then Attorney Vachon is going to ask the court to enter a not guilty plea on your behalf, and the court is going to do that. Then we're going to talk about dates when you return to court. And lastly,
Any guesses
Attorney
on the
Vachon
crime?
is going to speak on your behalf on bond or bail. and then the court will make a decision. Okay?
Get your guesses in quickly.
The most important thing I can tell you this morning is that you are innocent. You are innocent in the eyes of the law, and you remain innocent unless, not until, unless you plead guilty or found guilty beyond a reasonable doubt at trial.
Pamela Camel, really? Walmart.
And I say unless because it's different than until. Until means something's going to happen sooner or later, right? Unless means we don't know. So if I say we'll be here until Thursday happens, Thursday is going to happen. If I say we'll be here unless Thursday happens, suddenly that's a very different circumstance. So I say unless because we don't know what's going to happen in this case. You haven't seen the evidence. Attorney Vachon hasn't seen the evidence. Court hasn't seen the evidence. So you remain innocent unless you plead guilty or unless you are found guilty beyond a reasonable doubt. So that said, I'm going to read the charge against you.
Guesses are in. Let's see.
And it is alleged that you operated a vehicle while intoxicated. The specific allegation is that you did operate a vehicle upon a highway, East Michigan Avenue and Center Street, while having an alcohol content of 0.08 grams or more per 100 milliliters of blood, contrary to Michigan law, MCL 257.6251. If this offense resulted in damage to another individual's property or physical injury or death to another individual, you could be required to pay restitution. This is a misdemeanor, carrying up to 93 days in jail and or $100 to $500 in fines and or 360 hours of community service. You may also be sentenced to rehabilitative programs under MCL 257.625B5. You may be subject to vehicle immobilization. That's mandatory if you have a prior offense. You could be required to repay the cost of prosecution, to reimburse the government for the emergency response and expenses for prosecuting you for this charge. And that's allowed under MCL 769.1F. This is alleged against the peace and dignity of the people of the state of Michigan. Now, you have certain rights. You have the right to an attorney, and if you can't afford an attorney, the court will provide an attorney for you. I'm particularly proud of the superb public defenders we have on this court. Are you by chance a Michigan State University student? No, okay. So Attorney Vachon, will Mr. Gleason be applying to your office for services?
He will, Your Honor.
Okay, thank you. You have the right, as this case goes forward, to take this to trial. And at that trial, the prosecutor would have to bring evidence against you. You could question that evidence. You could bring evidence of your own, or you could just sit there, because it's the prosecutor's job to prove guilt beyond a reasonable doubt. And perhaps most importantly, at a trial, you could testify on your own behalf, or you could remain silent. And if you remain silent, no one could use that silence against you. They couldn't say, well, Mr. Gleason didn't have much to say for himself there, did he? No, not allowed, because you have a right to remain silent. At this point, Attorney Vachon, do you believe Mr. Gleason has an understanding of his rights?
Yes, Your Honor.
Okay, thank you. And how does your client wish to plead?
He'll enter a not guilty plea.
Thank you. The court accepts and enters that not guilty. So, Mr. Gleason, I have some dates when you're going to return to court, and you will receive these in writing at the address in Kalamazoo, unless we need to update that. Do we need to update that?
No, Your Honor.
Okay. So you're going to return to court for a pretrial conference at 9:30 a.m. March 6th. You'll receive these again in writing. A final pretrial conference at 2 p.m. April 8th, and for jury selection at 1 o'clock on April 9th.
Don't be late.
Now, please stay in touch with your attorney because these dates can change. Some of them you don't need to appear for. Some you may appear for by Zoom. Some you need to be here in the courthouse in East Lansing. Okay. Attorney Vachon, would you like to be heard on bond or bail?
Yes, Your Honor. I'd request a personal recognizance bond for Mr. Gleason. He did appear today as ordered, He has no prior criminal history to my knowledge. He is taking classes at the moment and he's also working. He's lived in Michigan his whole life. So he has a lot of ties to the area. For those reasons, I'd request a PR bond.
Meaning
Thank you.
personal
The court
recognizance.
is going to grant a
He
PR
promises to come
bond,
back.
but as I said at the beginning, Mr. Gleason, this is a worst case scenario hearing because courts exist because of worst case scenario. So if for some reason you don't show up, the court will issue a bench warrant for your arrest, and then you'll have to post $500 to get out of that lockup. So it's what we call a PR $500 bond. You don't need to post any money with the court today. Okay. Worst case scenario, you'd have to post $500. I'm going to put some other conditions on this bond. And first thing first, all right, so Mr. Gleason, you are to not leave the state of Michigan without prior permission of this court. Now, if you have
Grounded.
someplace to go for school or an interview or family, we have a form online. I can't make any promises, but I've signed every one of them so far, okay? The important thing is submitting it beforehand. Number two, and I always feel bad about this one, but there you have it. You may not commit any crime while released. Okay. Number three.
Sorry to have to do
You
this
must
to you.
immediately
Really to
notify
cramp your
this
style.
court in writing of any change of address or telephone number. Now, because I was a public defender and I got ghosted about every 7 minutes, you must also notify your attorney of any change of address or telephone number. Okay? No ghosting the public defenders. You may not use alcohol
Is that a law,
or
though?
recreational marijuana while this case is pending, or you may not use illegal controlled substances. Do you have a medical marijuana card? Okay, so you may not
No,
use
Judge, do you
marijuana
issue
at
them?
all while this case is pending. If you have any prescriptions, you are to take all medication as prescribed. You may not possess or purchase a firearm or other dangerous weapon. You may not engage in any harassing, intimidating, threatening, violent, or stalking behavior toward anyone. You may not operate a motor vehicle while intoxicated. I think that covers it. Is that all, Attorney Vachon?
Sounds complete.
Yes,
to
Your
me.
Honor.
Okay. So, Mr. Gleason, a few things. First, we see a lot of young people in this court for one bad experience, and then we never see them again in their lives. That is my hope for you. Okay. Second, the most important thing you can do for yourself while this case goes on is to ask your attorney any questions you have. Court is kind of like the Catholic Church. We do things in certain ways. We have certain rituals, certain phrases that mean a lot to us because we do it every day. It might not mean anything to someone who doesn't come here every day. Worse, it might mean something different. So whenever you have a question, ask your attorney. That will help your attorney represent you. Okay? So it looks like you'll be back soon. My hope is that sooner or later you will never have to see me again in your life. And I think you would like that a lot too. So we will see you back in the near future. Okay? Best of luck to you, sir.
All right. So that was really insightful. Sorry, hang on. Need that off. She just cut that off abruptly. She has a couple hearings coming up that I was hoping to catch. Let's see. She's got Ivan Robert Mile Baker and Jaipal Singh Nagy, all scheduled for arraignment at the same time. Looks like Mr. Nagy might also be a drunk driving, but let's see. Mile Baker, on the other hand, hang on. See what he was up for in case she comes back. Let's see. This Michigan court case search tool is not my favorite. In case you're wondering, this one is not it. Okay, arraignment. This is him. What did he have going on? I just want to see if they're going to come back. Now, retail fraud, $200 or less. That's all. All right, let's see. We've got some other stuff to go over as well. All right. Grader says, Recovery Addict ranks 50 states by the best court search tools. You won't believe number 11. This is going to be like the Greeners. I need you to write the what is it? The thumbnails for my videos. You won't believe what happens the second time you watch this video all the way through. Carrie says, I have to go get an echocardiogram today, a more detailed one than the doctor's office. A bit nervous, but watching this is relaxing in a way. Oh, man. My watch diagnosed a heart problem I had. My Apple Watch did. And I had to do what was it? Like a 6 or a 12. I forget how many leads. Let me just say, can I tell I'm not sure if it's an ECG or not, but you know when you go to the doctor to get your heart measured and they stick little patches on your chest all over and it measures. Yeah. Not sure if there were 4. I think there were 4 leads. So my watch told me there might be a problem with my heart because it was doing fun things. And so I want to check out my health. So I do go to the doctor and they didn't tell me. They didn't tell me what it would be like. Okay. I thought it would be, similar to like those little pulse meters you stick on your finger and they just measure and it's all good. But no, they said you have to wear this for 24 hours. And I'm like, okay, it's a little sticky pads they stick on you and then you wear a little thing and it's all good, right? It's all good. I'm like, oh sure, no problem. And so sure enough, I have my Fabio moment and strip off the shirt and they're like, wow, you must work out. No, they didn't say that at all. But they stick the little pads to me and they're like, all right, 24 hours. So I go home and I'm like, well, it's not really uncomfortable. There's wires all over, but it's just 24 hours. It's good. Go back to the doctor's office and they pull the little the leads off, but they leave those patches. There's the sticky pads, which I'm responsible to take off myself. They did not tell me that those patches have the same adhesive that's used in industrial strength rat traps. No mention of that whatsoever. So here I am with my little my little carpet of fuzz on my chest, and I'm trying to remove these adhesive patches, which are oversized. I mean, they're massive. Okay. And I'm sitting there trying to pry on this thing, and it's like the skin is coming with it. Oh my goodness, the skin's. So I get like a straight razor, okay? And I'm like pulling and trying to like trim each hair as it gets caught, wincing the entire time as I'm like pulling each one off, and just like eyes are watering. It's just like the pain was so real. So I'm like, okay, and I just pull and pull, and I cut each one, and my skin was just like red, the entire patch. And so I'm thinking, okay, maybe you just have to do the grit your teeth, put a belt in your mouth and bite it, double it over and bite it, and then just rip. That was a worse idea. It was a worse idea because skin comes too, and it just like takes like the top 4 or 5 layers of skin, everything it can adhere to, just like. There is no good way to. If I had known how badly that hurt to pull those things off, I would have shaved my chest as smooth as a baby's bottom. It would have been glistening smooth. I would have oiled up. It would have been there would have been nothing to grab, nothing whatsoever to grab. Oh my goodness, it hurt. Oh my goodness, it hurt. I'm not sure if this helps you or not. Carrie, I'm sorry. I ask them what to do. I'm sure there's a better way to remove it than what I did. Hopefully it's better. But my pain level for having chest hairs removed was not high. Was not high at all. I don't think you'll have that same issue, but I think I did it wrong. Oh my goodness! They can give you an adhesive dissolving wipes to help with that. Does that cost extra? I would have paid. I would have paid extra. Insult to injury. Insult to injury. Okay, I sort of told the story wrong. I felt something was wrong with my heart first. I'm like, something's weird. Okay, and so I went in and got it measured with that device, and then my Apple Watch, and then I put my Apple Watch and measured it, went in, got measured, and then came back out. So it's the Apple Watch reading came first. I felt it first. The Apple Watch reading came next. Then I got it measured. It turned up nothing, 0. As a matter of fact, the removal of the pads caused the very heart condition that it was trying to measure. The pain caused. They should have shaved. Yes, shaving should have occurred, but they're like, oh no, it's good. Just slap that thing on just let it mush it all into all that carpet of hair, and you should be good. Just yeah, there was no way. In the shower, underwater, it was so painful. And sure enough, as I'm tearing them off, my Apple Watch is like, is something wrong? Anyway, after that whole treatment, they looked at it and they're like, yeah, we didn't think it was going to catch anything. It never does, says the guy who's pulling the leads off me. And I'm like, you just did this for what? The money? If you knew it wasn't going to, be helpful. And so instead, I took my Apple Watch and it sent the report to my iPhone, and I showed him the little 2-lead report from my Apple Watch to my iPhone, and he was able to diagnose the condition from the Apple Watch because there was nothing on his 24-hour lead, nothing at all. But I did pay $1,200 for the experience, and not going to do that again. All right. I'm not sure. I'm sorry, Carrie, if that lessens your anxiety or increases it. That was not the intent. But apparently, get some advice on how to take them off. So, okay. Where are we? We were going to look at some courts. Let's see if Justice Lisa is back yet. She likes to divide up her docket by appearance. I wanted to catch another one to see if she was just as informative and kind with, say, maybe a repeat offender as she was with this younger gentleman who might have his first brush with the law. All right. It should be standard of care to shave men's hairy chests. I know that now, Paula, but there was no mention beforehand. And having it be my first ECG, I mean, I know that now. If I need to have another one, it's going to be like, hang on, I've got a date with Bic. Let's see. Oh my goodness. Big Sky DMC says, good morning. Are you planning on covering anything surrounding the Gilbert Goons in Arizona? Okay, this is an interesting case because the Gilbert Goons in Arizona is a case where now we have the parents of these teenagers who went around, beating people up or something. I forget what they did. They were just, causing general mayhem and ruckus. And the parents are now being sued and charged criminally. The parents are being charged for the teenagers' actions. That's what we're hearing. So I'm not sure if the filings have actually gone in. I'm not sure where they're at yet. But just a fun little note in this other court. The court's gone home for the day, but Zoom still cannot figure out how to hang up. So we'll see. She's still out there. All right. What's this? A slippery slope ahead, says Culperistic. Yes. So we'll look for that. If you guys see any court dates specifically on that, let me know. I'd be very interested in following that. Let's see. We've got a couple other things. Tashi says, I was born and raised in Gilbert, Arizona. That sounds like a Briar Rabbit. Is that what's the rabbit? It says, I was born and raised in a briar patch. That guy. That sounds like what you just said. In my head, that's how I heard it. Maisla, happy anniversary and Mardi Gras, Recovery Addict. Thank you for all the things. Maisla, thank you very much. Happy 12 months. Happy 12 months. It's been a wonderful 12 months. Wonderful to have you here. All right. Yes, that's him. It's another case of the parents being charged. I believe this is, I think they're, okay, I've said I don't think that the slippery slope is going to be a sudden rush to charge all parents who have kids that commit a crime. I don't think it's going to rush out to that. I think they're picking the low-hanging fruit. The Gilbert Goons case is civil. Right now, the case is civil. I believe we have it on pretty good authority that there is we've been texting some people in the know on the prosecution side that it was my understanding that there is a criminal charges coming as well. Okay. Culperistic, thanks for helping me procrastinate shoveling the snow. If you wait long enough, hang on.
Swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
I do.
Okay, I'm going to give you a couple of rules. You can put your hand down.
That's the first rule.
We need all of your responses to be verbal, so we need no head nods and head shakes. We also need yes and no if it's a yes or no question. You can't do and because that's difficult to put into the record. And there's also going to be a bit of a delay in some feedback, obviously, because you're appearing virtually. So if you hear an objection, I need you to stop speaking immediately. Allow us to make ruling on that objection, and then I will tell you if you can give that response or not, okay?
Okay.
All right, that's the same political court, so we're gonna bail on that one. But I just saw her pop on and wanted to see what she was all about. No, it's not Roger Rabbit. No, it's not Roger Rabbit. Culperistic. If you wait long enough, the snow melts. The snow melts. I've learned that from my own experience. KH in South Carolina, 13 months. So glad to be here. Thank you, Kate. It's wonderful to have you here as well. Congratulations. All right, we've got, who said sleep study? How do I sign up for a sleep study? I'm pretty sure I'm going to fail it, okay? Mostly because I snore. But I can sleep faster than anyone else I've ever heard of. I'm not sure if that's a good or a bad thing. Maisla also gifted one membership. Thank you very much, Maisla, for gifting a membership on your 13-month anniversary message day. 24 hours. Oh, whoa. They make you wear the leads for a sleep study? I thought they just like gave you a watch or something. Put a little clamp. I'm not going to do the leads again unless I have to. It's going to have to be serious. So sleep study is out. LJ, thanks for the warning. I was thinking, sign me up. I get to go somewhere and sleep. That sounds like fun. Let's see. Vicky says we're trying the Ecker trial in Minnesota, Ramsey County, where Bruce Rivers is the defense attorney. Oh, hang on. Guys. Wait. Hello?
You are currently the only person in this conference.
Hello? Hello? Man. What can I do to get people not hang up when they call me as a prank call? Is it because I have the deep bottom radio voice? I could turn that off. What part of only person in this conference didn't you get? Oh, man. 20th Century Fox says the sleep study sticky things are not very sticky at all. Don't let that hinder you. Okay. I just thought it was like, I was thinking more, I wanted to go be like a tester for mattress companies. I'm like, hey, we've got this new extra comfortable mattress. Will you come test it for us and then tell us how wonderful it is? I would do that. I wasn't as keen on being the subject of the survey. They like old people be a granny, says V. I might have a voice changer I could do. I always feel like a noob when I hear these year-plus members. So happy they have finally subscribed. Thank you for 5 months. Appreciate that, Allison. Wonderful to have you here as well. My husband did an at-home sleep study. Okay, let me. You keep talking about sleep studies. I've got to find our next court case. As always, if anyone sees some of our good old regulars, let's see. Oh, it looks like Judge Boyd is back on. Let's see how she's doing. Yeah, she just got on here. It looks like we missed about the first 25 minutes, but let's just jump on where we are right now and see how that's going.
You got to let them know what the side effects are. You understand?
Yes, ma'am.
Because if you don't talk to them, they don't know. In this court, to be successful on probation, communication is key.
Yes,
If there is an issue and you feel like probation is not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am, I do.
Yeah. So from here on out, everything that you do, your range of punishment on this case, if you were to mess up, is up to life in prison. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
And counsel, are there any health issues with him? I see issues with his arm.
Not that I'm aware of, Your Honor.
All right,
Mental is the issue.
All right, thank you.
Yes, we'll try to leave people on the first row, Judge. Okay,
all right, I appreciate it.
Absolutely.
Okay, yeah, you can put them on the first row. Okay, they can be put on the first row, but there's going to be consequences for lateness. All right, Kendall Blunt.
I've got to fix her audio. I've got all sorts of filters on that are making it messed up.
Hello.
Good morning, Judge. How are you?
Hi, all right, well, I see wearing cap.
Muslim.
Oh, okay. All right, so what's going on?
We are.
Melissa Vega at the live desk happening right now as we continue to follow the very latest for you on the Capitol murders.
Sorry. I'm like, where's that coming from? It wasn't from there.
That's some stuff that was given to the first defense attorney, which a pile of discs was not handed over to them. So we are in the process of getting new copies made and given to them at this point, because those things were not put on e-discovery. They were just had a discovery acknowledgement form from just the first defense attorney, and they double checked all of their stuff over the weekend, and they do not have those discs.
Additionally, there were some cell phone stuff that they weren't able to open. There was another cell phone dump that until Friday, they weren't able to even open themselves. So that's a new discovery matter that has since been resolved.
So here's the issue the court has. You said y'all discovered this late at night.
But it was late in the day on Friday.
Oh, okay, because I was just gonna say, you gotta have work out, life outside of work.
That's all right.
It's about 4:30, Judge.
And then we met yesterday. We continued. I gave them some drives so we can get all the stuff from them. And then we also, as the court's aware, we were looking at our calendars for some matter. We had two other family violence and myself had two matters with the court yesterday that we picked some dates on with you. So when we were going through the calendar, we also went through the calendar anticipating today's setting. So we also looked at the calendar for this case as well.
All right, so what date for jury trial?
September 16th.
Can somebody send me a link to this
one?
one?
In the interim, Judge, if you want to have another, within the next few months, just to make sure that we have all the discovery compliance handed over, we're also fine with that too.
No, I'm not gonna do any more discovery compliance settings. Everything should be done.
Yeah.
So y'all don't have to do that off the record.
Okay.
Of course, if there's an issue that something has perhaps been purged or something of that nature, you can just approach and the coordinator will put it on the docket. But your jury trial is going to be September 16th. And how long do y'all expect the trial lasts?
Week?
Probably 7 to 10.
Yeah.
A week and a half.
All right. And why were you late?
Caught up in traffic and the detours downtown.
Okay. So this is not your first time being late. So of course, sometimes I do things for rehabilitation. Sometimes I do things for punishment. So as your punishment for being late, you know what's going to happen? You're going to enjoy the lovely day with us in court. You're going to be here until noon. Do you understand?
Yes, ma'am.
That's for being late. My mom and my grandmother always told me, whenever you're late for something, you know what that tells somebody? That my appointment that I had with you, not important, and you're not important. So you're going to stay with us, but your Court date is going to be September 16th, all right?
This month.
So Deputy Mr. Blunt is going to join us till noon.
You want him in the box?
He can be on the first row. Thank you.
Thank you, Judge.
You're welcome. Luis Miguel Hernandez.
We got a forced spectator for being late.
Good morning.
Good morning.
Judge's mic is a little bit messed up today. I'm not sure why. Doesn't sound as good as normal.
So where are we on this case?
Your Honor, we're still conferring. Mr. Hernandez is requesting an opportunity to hire counsel, so I don't expect this to resolve today because he would like to hire counsel.
Well, today is jury trial day.
I understand. I've explained as much to him.
I mean, you can get an attorney in here to represent you today, and they can come in and represent you today, but we're going to jury trial today. You understand?
You know what? I wanted to use a motion to get it tested, the substances.
And here's the thing. Today is your jury trial day. So we're going to trial today. All right, thank you.
Thank you, Your Honor.
Fernando.
It's a little late to
Cordova.
get an attorney, but jury's here.
Good morning, Judge.
Good morning.
The audio is bad. I'm trying to find.
Good morning. How are you doing?
I'm doing well.
All right. So what are we here for today?
It is a motion to withdraw as counsel.
Motion to withdraw as counsel. Why?
Can I see the motion, please? Yes. They're gonna pull the motion and we'll take that out.
It's just like the
right,
judge's
thank
mic
you.
is like covered or something.
Do you want us to sit back down and wait or?
No, well, what's your, yeah, you can go ahead and print the motion and I'm sure you remember the reason for your motion, correct?
Yes, Judge, I was terminated.
Are you appointed
No.
or retained?
Retained.
So he was,
All right, we're gonna go
he
on the
was
record.
fired by his firm and he has to withdraw.
State, this is a motion to withdraw. I've been informed, they're printing the motion out for me, but I've been informed that the defendant is firing his attorney.
Okay.
And he's retained, so he has the ability to do that.
Okay.
Court is calling 2023 CR 11045, State
Never
of
mind, the
Texas
defendant
versus
fired
Fernando
his attorney.
Rene Cordova Mejia. Can I have parties announce for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
John Pettis for defense.
And are you Mr. Cordova Mejia?
Yes, ma'am.
All right, your attorney has filed a motion to withdraw. Are you aware of that motion?
Yes, ma'am.
Okay. Counsel?
Judge, I've been notified by my client that he wishes no longer to proceed with my services. And he wants to instead try with a court-appointed attorney.
All right. Any objections to this motion to withdraw?
No objection from the state.
All right, then you're withdrawn.
Thank you, Judge. May I be excused?
Yes, you may be excused.
Thank you.
Do you need an attorney appointed to you?
Yes, ma'am.
All right. So just have a seat and we will get an attorney appointed to you, all right?
Okay, thank you.
Wow, he's rolling the dice. Fires his attorney and rolls the dice. Might be a financial issue. Attorneys, I hear, are expensive. I thought he was fired from his. I thought he was saying he was fired from his firm and he had to withdraw, but no, the client fired him, which makes a little bit more sense.
Can I approach real quick?
Yes.
No handshake, no good luck. It was a good riddance. Don't let the door hit you on the way out.
We're going to be able to and I've let the listening team know about it, so I'm hoping that
I'll bring in another feed and see if I've got just a poor connection here.
Norma, can I see the file on Jesse Garcia? Yes. Thank you. Yes. It's 2023-9548.
Okay, let me just pull up another feed.
All right, thank you.
Okay, we've switched feeds.
I think Mr. Pettis left. Yes, I've already sent it. Oh, that's good. Oh, okay.
I do think it's her microphone is turned off. The reason I can see that is on Zoom, the audio box when she's speaking remains the green square remains around the rectangle remains around the court side. So her mic is just off. That's it. It's nothing I can do. It was seamless. Hang on, something just hit my house.
They're not ready. Roxanne Garza? And then Norma on Jesse Garcia. That's Christine Brown. She's here. Present. Oh, hi, thank you. Yes. Christopher Escobar.
Everything's good. It was my my Airbnb partner who's making a slight modification to our water line so we can track water going out to the Airbnb, and he was slamming a door that he has access to. All right. Don't go outside. No.
Nicole Villarreal. Amanda Drummond.
What did I miss? Anything exciting? She's just quiet. I'm used to having Judge Boyd be full volume. It's awfully quiet. Oh, that's what's wrong. I'm in the wrong size. I feel small. One day. Zoop. Now we're back. I was bringing the drama. Airbnb is right next door. It's a detached building. So yes, it's on our same property. It's detached. Separate structure. We just it's fed on the same water lines, same power, same water lines, same it's the same Ethernet, but it runs through a VLAN, so they can't see what I'm doing. I can see what they're doing, but not legally. I'm just saying technically I can see what they're doing, and they can't see what I'm doing. But it's on a VLAN. So, did you book a traveling nurse? Yes, we're finalizing it right now. I think we're just waiting for the signed contract. Wind is crazy. A lot of rain as well. I'm not sure what the judge is reading here. I missed it. What's happening?
All right, just give me 5 minutes, everyone.
Oh.
I'll be back.
I'll be back, says Judge Boyd. We'll keep that going there while I look for a couple other options. We are going to be court hopping today. There's not, let's see. Let me see if this one. Let's see if we can go back and watch the DeSoto case. You guys familiar with the Savannah Soto and Matthew Guerra case? This is in San Antonio as well. Happened the other day, so let me stop. Let's do that. While we're waiting for the judge, let's see if we can jump to this one right here. There we go. So this is a replay of previous events we're going to talk about as it happens. Weebug, yes. Thank you. I've got one sitting right here next to me. It's full. The other one we're waiting for them to have a lid for. And we're getting them one at a time. This is Bexar County. This is the case that happened yesterday, the first appearance, I think. This is the dad of the son.
Call CM 116056 and CM 116070.
Let me throw a high-pass filter on here.
Versus Ramon Preciado. You can have both sides announced, starting with the state.
Austin Scott from the state and Tamara Scott from the state. Good afternoon again, Judge. John Coons and Megan Enriquez from Mr. Preciado.
And we are here on a referral from the 290th District Court. Mr. Preciado is seated and present in the courtroom. These are both motions to reduce bond filed by defense. So defense, go right ahead.
Thank you, Judge. We would call our client as a witness.
I'm going to speed this up. Motion to reduce bond. He's accused of hiding the bodies in the car.
Sir, can you raise your right hand, please?
Yes, sir.
Do you solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Just make sure to speak into that microphone and do not speak over the attorneys. Wait till the question is asked before you answer. The court reporter can only take one person speaking at a time.
Yes, Your Honor.
Defense, your witness.
Thank you, Judge. Good afternoon, Ramon.
Good afternoon.
Your name is Ramon Preciado,
Yes, sir.
and you're currently in jail on 2 charges, is that correct?
That's correct.
And I'm going to read off some case numbers. I'm not asking you to know them necessarily, but I'm just going to read them off and tell you what they are. The first of which is CM 116070. It is charged as altering, destroying, or concealing a human corpse, and the bond on that one is $500,000. Does that sound right?
Yes, sir.
The other case you have is CM 116056, and that one is entitled Abuse of a Corpse, and the bond on that one is set at $100,000. Is that correct?
Yes, sir.
So you have 2 bonds that total up to $600,000. Is that correct?
That's correct.
You've been in jail for how long now?
Going on 42 days. Not sure exactly.
So did you say 42 days?
Going like 40.
6 or 7 weeks maybe?
Yes, sir.
And you have not been able to make a bond at the amounts that they're set at right now, correct? Is that correct?
No, sir.
Do you have assets to sell on the outside that could get you enough money to make the bonds at $600,000?
No way, sir.
So let's talk about the properties or assets that you may or may not have available to you. Do you have a vehicle?
They took the car in as evidence, I guess you would say.
So you don't have access to a vehicle to sell, do you?
We have another truck. It's probably worth maybe $3,000 if we're lucky.
$3,000?
Yeah. My wife probably thinks it's a little more, but no, the engine's kind of bad. Transmission's leaking and it's knocking, so, I know a lot about mechanics. It's probably not.
Like the engine is knocking?
Yes, sir.
Do you own land?
No, sir.
Do you own your own house?
It's actually my wife's house.
And there was some testimony by your wife the other day in terms of the house that you live in. Is that what you're referring to?
That is correct.
Is somehow a gift from her father to her and some other family members?
That is correct.
So her interest in the home is only 1/4 of the home?
Yes, sir. It's divided by 4.
Do you know roughly how much that house is worth?
No, not really.
Is it worth $1 million?
No way.
Is it worth $500,000?
No way.
Do you know how much equity there is in the home?
I couldn't say, probably not much.
Not much equity.
No, I don't think anything would be worth it.
In fact, your wife is paying on that house, is that correct?
That is correct, sir.
And you guys have been in it for how long now?
Between 9 and 11 years.
Have you had Has anyone in your family or friends tried to get bonds for you while you've been in custody?
No,
Is it because the amount is so high?
nobody has that kind of money.
Nobody in your family?
No, sir.
So let's keep talking about assets. Do you have gold bricks somewhere?
No, sir.
Do you have a large cash deposit somewhere?
No, sir.
Do you have a safe full of jewelry or cash or anything like that?
It's all in the pawn shop. Might have a couple of little pieces later on here or there, but maybe $300 for it. They're mostly sentimental value, you know what I mean?
You said about $300 worth in a pawn shop?
No, in the pawn shop, that's the ones that I've been buying them since the end of summer. Things got
here. Is that correct?
That is correct.
In the summer of 2023?
Yeah, they're still in there.
And it would cost you money to go get them, is that correct?
Yes, sir. A lot.
So you don't even have access to them right now, do you?
No, sir.
You have to raise money to get them out of the pawn shop, is that correct?
Most definitely.
Now, again, you don't have stocks or bonds or anything like that?
No, sir.
Do you have any other assets that you could sell reasonably quickly?
Tools, but again, digital gauges and stuff like that, they're not worth much. You might buy them for $600, $700, but once you use them 3 or 4 times, they're all digital, they're not worth much. You'd be lucky if you could sell them for $10, $20. In our line of work, they get damaged real easy.
And your line of work is HVAC, right?
Contracting, yes, sir.
HVAC.
Let's talk also, since you've been in jail, you've had some medical issues, is that correct?
That's correct.
Let's start with the medical episode you had just a couple of days after getting arrested. What happened?
They were walking me into a room, and I had an episode and I fell back, I hit my head, and it bounced off the metal door, and I slammed my 300-pound body on the floor, and I bounced, and a bunch of sheriffs went over there, one of them tried to get me up, and I kind of started seizing like this, kind of stayed like that for like, I don't know, a few minutes, and I was gonna die. I tell you, it just kind of really scared me, and I got up. I was breathing real hard, and they took me to see the doctor, and he said it was just an episode or my medicine, because they're not giving me my medicine the way they're supposed to exactly. So like I'm supposed to get it right before I eat or right after, and it's like you really need to take that medicine the way you're supposed to, because you go into a coma with sugar. You don't drop that, and I already had that. So 7 times since I've been locked up, 7 times that my sugar, I'm sweating. This I know for a fact. I was sweating, couldn't breathe, and I even rang the guard. Real nice guy, but they're not doctors. I mean, they just made a.
Ramon, let me stop you for 1 minute. When you went into the jail, you already had some health conditions, is that correct?
That's correct.
And what health conditions do you suffer from?
I'm diabetic. I have high blood pressure, cholesterol, I have sometimes breathing problems.
Were you on medication for any of those conditions before you went into the jail?
Yes, sir.
Since you've been in the jail, have you been getting the medication in the correct dosages and at the right times?
No, sir. Sometimes they're 6 to 8 hours apart before I eat, and that just throws me everywhere. Like I feel dazed, nauseous, episodes. You know, I don't even know where I'm at sometimes. They're walking me somewhere. I don't know where I'm at.
Are you afraid that because of the substandard medical care you're getting that you might have further health problems?
It got a lot worse, that's for sure. I can tell you when I went to a specialist, my kidneys, they're giving me the same medicine they're giving me now, the metformin, and that's what was hurting me real bad then. And that's why I told them that where I'm at, I can't take the metformin. You're overdosing, you're over medicating me. You're gonna kill me. Because it's happened to me before. You're giving me 2,000 milligrams. And my medication is nowhere near that, and it's not metformin. Nowhere near that. 2,000 milligrams is a lot. It'll knock you out like that. And imagine taking it while eating.
Okay, Ramon.
Mike's
you have a doctor on the outside.
Kind of clicking really badly.
And you've actually even seen specialists, haven't you, in the past?
Sir.
Were you having these kind of fluctuations up and down when you were on the outside before you were locked down?
No, sir.
No, sir. Got to get rid of the 2 times speed.
Really keeps a good schedule and keeps me on it, you know what I mean? Even though if I work, she'll call me and let me know.
Are you asking the judge to lower your bonds?
I'm actually begging him to lower the bonds.
And if the judge was kind enough to lower the bonds to an amount that you are able to get out, or your family or friends are able to get you out, will you comply with any and all conditions?
Yes, sir, I would.
You have a couple of different options for residences when you get out, is that correct?
That is correct.
One would be your old house.
That's correct.
The other, if that doesn't work out, the other would be with a relative.
That is correct.
Are you from San Antonio?
Yes, sir, all my life.
Is all your family here in San Antonio?
45 generations.
And the two residences that you have as options are both here in San Antonio?
Yes, sir, they are. My whole life is here. Not to mention I have a sick wife and a sick child in the Bexar County.
So, Megan just reminded me, there's some testimony by your wife the other day about a bank account that maybe you guys have, and I think she testified it had approximately $3,500 in it. Do you think that that's correct?
No, sir, it's probably negative.
It's negative now?
Definitely.
So you don't even have that kind of cash available for a bond, is that right?
No, sir. It might have had influence, but we were paying bills. I mean, it is what it is. People have to eat. People have to pay bills.
Were you guys behind a couple of months on your mortgage at the time you all were arrested?
Going on 3 months, yes, sir.
Where were you when you got arrested?
At my house.
And do you remember what day it was that you got arrested?
Not exactly, sir. No, sir.
It was in January, wasn't it?
Yes, sir, January.
And had you attempted to leave San Antonio in the few weeks that this investigation was ongoing?
No, sir. All I know is San Antonio. All my family's here.
Had you tried to get a passport?
No, sir.
Had you tried to book a flight to Greece?
No, sir.
Had you made any plans whatsoever to leave or abscond from San Antonio?
I have nowhere to go. My family's here.
Ramon, you have, when you were younger, in your 20s,
Statues and they playing the guitar next to the judge.
Correct?
That's correct.
And you had done, on the state side, you had done probation, is that correct?
That is correct.
And you had successfully completed those probations, is that correct?
Yes, sir.
On the federal side, about 24, 25 years ago, you were prosecuted as well?
That's correct.
And did you ever have any violations when you were on supervised release?
No, sir. She actually commended me on doing a very good job, always showing up on time, paying what I need to pay.
You never fled when you had those cases, did you?
No, sir.
You never tried to run, did you?
No, sir.
And you complied with all the terms that the judges asked you to comply with, is that correct?
That's correct, sir.
Do you have a job?
Yes, sir.
And it's in HVAC, or I'm sorry, you said contracting.
HVAC, you're correct.
Do you intend on going back to work if you can?
It's besides my wife and my child, it's my life. That's all I've ever known.
Judge, I'll pass the witness at this time.
State your witness.
Trying to get his bonds lowered.
Now, there's been some mention of your wife. Is that Mircha Romanos?
That's correct.
And how long have you guys been married?
She would tell you the exact date. I could tell you it's pretty close to 30 years. Not exactly married, but together 30 years. But yes, 30 years.
You guys are married?
Yes, sir, we are.
And what children do you have?
We have Christopher Ray Preciado.
That's your only child?
Judge, may we approach?
Sure.
Why I don't know why there's an objection right there.
Do y'all have any microphones here?
Yes.
In front of the bench? Just the one in front of the witness?
Okay, Mr. Preciado, so you were saying that Christopher is your only child with Mr. Mott, is that correct?
Yes, sir.
Okay, but you have other children as well, correct?
They trimmed it out.
That's correct.
How many other children?
Two.
Two other than Christopher?
Yes.
Okay, what are their ages?
It's hard to remember when you get older. Hold on, give me a second. 30 and 28.
So they're adults?
Yes, sir. They have their own lives. Yes, sir.
Do they live here in San Antonio as well?
The whole family is in San Antonio.
And living with Mr. Romanos, you were living at the residence on Charlie Chan?
That's correct.
Okay, and that's what you're talking about, the house that you guys have. That's the residence you're talking about?
The house she has, yes, sir.
And did she inherit that house, or was it a gift?
That's correct.
So it was inherited?
It was a gift. It's for them. She had to tell you the details. I don't get in her business like that.
And Mr. Romano, she has been unemployed for about 14 years, is that correct?
I would say it's about right. I'm not sure. Again, I don't keep up with that. I mean,
Well, does she work?
no, sir, she doesn't.
Has it been a long time since she's worked?
It's been a little bit, yes, sir.
So since you guys started living in this house, has she ever worked while y'all were living in that house?
She wasn't working before that.
So who was making the monthly mortgage payments on that house?
Her dad would help us.
And he passed away in 2019?
I believe that's correct. You would have to ask her.
Okay, was he helping you up until that time?
Off and on, yes, sir.
So after that, who was helping make these mortgage payments?
You're looking at him, sir.
Because you're the kind of the breadwinner in the household.
Yes, sir. To the best of my knowledge.
Okay. And about how much is that mortgage payment a month?
It's hard to say because it changes. I think we started with 11. I think now it's up to 18 something. So I cannot give you that. I could tell you what's going for right about now.
It's a variable mortgage.
Okay, so somewhere between 1,100 and 1,800 in that neighborhood.
It's 18 right now, 1836 or something.
Okay. And you said you're about 3 months behind on it, to your knowledge.
Can give or take. I haven't been here almost 2 months, so you know.
Are you aware of any payments that are made towards the mortgage since you've been in the jail?
I think my sister might have tried to make one a payment or something.
And I know you said you weren't sure about the value of the home, but do you have an idea of how much equity you guys have in that house?
I have no idea.
And would surprise you to know that Mrs. Romanos believed it was about $100,000?
She probably would say something like that, but she doesn't know. She's just guessing. You probably put her on the spot. She probably just said something, some number. She has no idea. She doesn't keep up with that stuff. But if she said 100,000, she's very intelligent. She might have looked it up or something.
Because the house is in her name, so she's kind of the one who deals with that aspect of it.
That's correct.
It's the bond hearing.
Mr. Romano said that you guys had a vehicle that was worth $12,000. Would she be talking about this truck with the mechanical issues that you mentioned earlier?
I think it's the truck that y'all took.
What's that?
The truck that y'all took for evidence.
This is the dad of the son who was accused of shooting the couple in San Antonio in their
Give
car.
or take, it's of 2014 or 15, so yes, I would say so.
But you think the other truck you guys own is worth about $3,000, I think is what you said?
Unless you put a new engine in and transmission, and you probably could pick it up, but at that point, you'll be, might as well get in a vehicle.
And how much do you think Christopher's vehicle is worth?
Christopher doesn't have a vehicle. They were just they lent it to him, and it was actually my sister's vehicle.
And that vehicle's been sold now?
I have no idea what's been. I've been in here, sir.
But you've been communicating with your family and speaking with them since your incarceration, right?
That's correct.
You speak to your son and your sister pretty regularly, right?
To the most part.
And in fact, I mean, your family's been helping kind of liquidate the assets you guys have in the house, right?
I told him to move some of the personal items out. Yes, sir. The things that meant stuff to us, meaningful stuff. Not nothing expensive, but just stuff that means something to us. You know, you might have something that you have that you love as you're a child. It might not be worth nothing to anybody else, but it's worth something to us. You know what I'm trying to tell you?
No, I understand. I'm just trying to understand what efforts your family's been taking to sell things on your behalf.
Well, I want to say things is just a few little things. They haven't even sold anything yet. I think it's just little stuff they put away. So until the house doesn't get robbed, pretty much have an open target. So every day people are doing crazy stuff around there, breaking windows and anyway, other stuff.
Did you, in fact, your son rented a U-Haul truck and to haul all that stuff out of the house, right?
I didn't. He probably took little stuff that would help him out. Yes, sir.
But the idea,
when you say U-Haul, you use the word U-Haul. People think it's a big truck. No, it could have been a little bitty truck that he just took what he needed.
But I mean, the understanding is that he's selling these things to raise money for you guys. Is that correct?
As far as I know, he's not tried, but he hasn't sold anything yet, sir. He's just trying to put little stuff. He wanted to break into the house.
And the idea is he's going to store the stuff somewhere and sell it at a later time. And that's what is what he says. Who knows? He'll probably be sitting there, 2 or 3 years from now. Kids say something, they do something else. That's just the way it is.
This is a bond reduction hearing.
Hopefully, one
His
day
bonds
maybe
right
get
now
a
are at
little bit.
$600,000.
We have to buy meds. We have to pay bills. Bills have to pay. Be done. Poor people. That's how they do things. Poor people sell stuff to buy their meds. Poor people go and sell stuff to buy food, to pay bills. That's how we pay bills. When you don't have no money, when you don't have a regular check coming in. Do you understand that?
Thank you, sir. Your meds are being paid by the citizens of Bexar County right now, right?
They are giving meds, not the ones I need. Yes, sir. You are correct.
We'll talk about that in a little bit. But in terms of what's been going on at your house, the idea is that everything's going to be moved out of this house and sold eventually, correct?
That's not a true statement. Some things are being moved, little things, yes, sir.
The plan is that house is going to be sold as well, correct?
No, sir, that's also not true. We're deciding what we're going to do with the house. We just don't want it destroyed in the process.
Have you talked to your sister about selling it on open door?
I have, and we discussed it, but there's no final saying. It's just the ideas. You want to sit there and starve, or you want to come up with some ideas? We're coming up with ideas.
So, I mean, that's what's been going on in the last 6 or 7 weeks since you've been incarcerated. Is you guys have been actively trying to raise money for your bail.
We have to eat. We have to pay bills. We have to come up with an idea.
Well, your food is being paid for by the jail, correct?
That's a true statement, but again, all food I can't eat. Why do you think I'm sitting here? Lost some pounds, feeling sick, shaking, having chest complications. So when you say that, it is a true statement. I am not eating what I'm supposed to, not feeling like the way I'm supposed to, not taking my medication the way I'm supposed to, and not feeling the way I'm supposed to, shaking, having episodes. I wasn't having episodes like that. I've never fallen on my face, head, and hurt my ribs. I have never, ever walked somewhere and not knew where I was.
Just answer the question that I asked you, please, and nothing else, because I'm just trying to...
I apologize.
That's okay. There's just certain things I have to ask you that are relevant to this hearing about bond. It has a lot to do with money that you're raising for your bond, so that's all I'm asking about in terms of that. But so if I understand correctly, has any amount of money been raised for your bond since you've been put in there?
No, sir.
But yet your son has been off selling things since that time.
If you can show me a receipt, I believe you, but I doubt it.
I mean, he hasn't told you that?
He always says, "Oh yeah, I'm gonna try to get rid of this. I'm gonna try to sell this," but he's probably sitting there. I guarantee you. I know my son. He always says that. He's a workaholic. He works 3 or 4 jobs. You know what I mean? And he paid very little. So, I guarantee they're sitting somewhere.
And prior to being incarcerated, you're aware that you had a large amount of jewelry in your house, isn't that correct?
Pawn shop, yes, sir.
And also in your house.
There's a little bit left, yes, sir.
And it's like in your pockets and things like that, in your clothing?
Yes, sir. When I come somewhere, I'll put in my pockets when I come home. Who doesn't? Some people leave it on the dresser, some people leave it there. Who doesn't?
Has your son been instructed to sell those things to raise money for your bond?
No, sir. If you heard that, you must have heard it wrong. What I said was, put it away. Some of those are family heirlooms. And what I said though, but if you needed a few dollars to get something to eat or put gas, do what you gotta do, you know what I mean? Because again, we have to eat. That's just the way it is with people.
Do you support your older son who's out in the real world?
Do I support him?
I mean, financially.
Again, he's a workaholic. I haven't even seen him in who knows how long.
Do you support him financially? So I'm asking because you keep saying that you're letting him sell things to raise money for his food and things like that.
No, sir. What I said was, I'm letting him take care of the things. You're the one that said in that category. Yes, if he needs to get rid of things, if he needs to get something to eat, he's not going to expect it to do it for free.
Well, why would he need money from your jewelry all of a sudden just because you're in the Bear County Gym?
You're the one that said that he needs money for it. I said if he needs something to get something to eat. That's what I said.
Well, again, the question that I asked you was, do you support your older son financially?
No, sir, I do not.
Got a straight answer there.
Now, have you ever had to deal with bond companies before?
No, sir.
And so are you aware of kind of their practice in terms of what they require as a down payment for any kind of bond?
I've heard a little bit, but not really.
What is your understanding of how that works?
They want 10 to 20% or something like that.
So 10% or of the amount of the bond?
It's kind of my understanding. I haven't talked to anybody, I haven't dealt with anybody.
I know you haven't, but are you aware if your family has called around and checked?
No, sir. They don't have that kind of money.
Have you asked them to, well, how do they know if they haven't called around to check?
Because nobody has $1 million, 600,000 laying around. Nobody.
Well, you know that your bond is right now set at a total of $600,000. So, but you don't know what a bond company would require in terms of the amount needed to make that bond.
That's a true statement, but again, they want to have that kind of money.
Well, how do they know what they need if they haven't called and asked?
Sir, there's no way my family had 100,000, 80,000, 50,000 just to put somewhere. They got kids, they got families. There's no way they could put that kind of money, and that's the truth. There's nothing to say, nothing to give, nothing to be taken. If they don't have it, they just don't have it. Not that they don't want to help, they just don't have it.
You don't know if a bond company, any particular bond company would do a payment plan, or you don't know what the terms of that would be because you guys haven't called around to check.
No, sir, I've been here, I have not. That's a true statement, I have not. But again, I have not called, I have not talked to nobody.
But you haven't asked either your older son or your sister to do that either, right?
I told my sister to look around, but she doesn't have no idea what's going on with them. She doesn't, it is what it is.
To your knowledge, no one in your family has called around and checked with bond companies on your behalf?
No, sir.
And you said that if you were to be released, you would either reside at the residence on Charlie Chan or with another family member, correct?
That's correct, yes, sir.
That other family member, does that person live in San Antonio?
All my family is in San Antonio.
Does that person live in San Antonio?
Yes, sir.
Okay, so that home would be in San Antonio?
Yes, sir.
All right, are you aware of this, like the situation at your house on Charlie Chan right now, what condition it's in?
I'm scared of the thought.
Does it have running water?
Probably not.
Does it have access to electricity?
Probably. I think my son said he tried to take care of that.
So it's possible it doesn't have access to electricity.
No disrespect, but I don't know. I don't know nothing about the house.
I know, that's what I'm trying to say. You're saying this is a place that you would go, but you really don't know what the situation is over there, or whether that's a good option for you.
Well, again, sir, that is a true statement, but I have to live somewhere. So it would be either with my family members or the house. You ask me where I would live, and that's what I'm telling you. I would have to make the best of it.
Are you a United States citizen?
Yes, sir.
And do you have a passport?
No, sir.
Have you ever had a passport?
No, sir.
Have you ever traveled to Mexico?
No, sir.
Never?
I don't know the way in Mexico. What would I do in Mexico? Don't let my brown skin fool you.
It's a yes or no question.
No, sir.
And you said earlier, I just want to clarify, sorry. You said you had a sick wife and a sick child in Bexar County. Are you referring to Ms. Romanos and Mr. Preciado?
My son and my wife, yes, sir.
Why are you saying that they're sick?
Because they are sick. My wife might sound good, but her sugar's out of control. She plays that real tough, but she's not. She's sick. You can see it in her eyes. When she walks, when she talks, that sugar's so out of control. Most of the time, you can't. Her numbers are just everywhere. And I know, because I've seen her check it. And it's 300 or 400 sometimes 200, 300. Sometimes she doesn't eat nothing. She's so spoiled, sometimes at 500. So I know this. And Christopher, he has breathing problems. Sometimes I stay up and just watch. We stay on watching him. Because I'm worried he won't wake up in the morning. And that's reality. And they're both sitting in Bexar County jail right now. And yes, I know what is going on, what y'all are saying. I understand that. But again, they're sitting behind bars. And they're both sick. Whether you think that's true or not, you can check their doctor records. You can check, and they'll tell you what's going on with Christopher. And my attorney will give you a list if you want. And there's nothing to say anything else. I mean, that's the truth. There's no lying. Doctors don't lie. They write it down.
Well, it surprised you that she didn't mention that at all during the hearing the other day?
Again, I told you she's a strong woman.
Just circling back real quick to the bank account situation. You know, you said you believe that your bank account is probably negative. Is that what you said?
I don't know where I'm checking it, but yeah, most likely 90% is negative.
Now, you guys don't have just one account. You have multiple accounts, right?
No, sir. Me and her share an account. She has a personal account.
And then you share an account with her aside from that?
No, sir. We have an account together. Then she has her own little thing that sometimes she works with Chris.
That account that you have together, is that your business account?
Yes, sir.
Okay. And what is the business that you have an account for? I mean, what generally? I'm not asking for the name of it or anything like that.
It's an air conditioning contractor.
So what kind of work do you do? You're an air conditioning contractor. I know you testified to that. You've been doing that a long time, correct?
All my life, electrical and air conditioning, sir.
Who do you contract with in general? Are you contracting with residential people?
Residential, commercial.
Residential and commercial?
Yes, schools, yes, sir.
And what is the name of the company? Judge Cooley approach.
Get ready for the cut. There we go.
Mr. Preciado, how long have you had this account?
To tell you the truth, between 11 and 13 years. Don't quote me exactly, but right around there.
And are you the owner of the company?
I like to say my wife's the owner, but I'm the boss. But yes, I'm the owner.
And do you have any employees?
I contract out if I need to.
For employment or labor?
If need to.
Okay.
Including Christopher is the one that's been helping me.
And if you're not contracting out, you don't have any employees?
Say it again?
If you're not contracting out, you just don't have like regular employees on the payroll?
Sure I do. Me and Christopher. And most of the time me. So we're still considered employees. Might be the owner, but I still try to wrench.
Is your wife on the payroll as well?
She's not on the payroll, but she helps me with the paperwork.
Okay. And do you know how the business is organized? Is it a sole proprietorship or an LLC?
Sole proprietorship.
And so you pay taxes on all that income?
Yeah, most definitely. Yes, sir.
And again, I know you're saying you're doing residential and commercial, but how do you get business, new business?
Advertisement.
So do individuals call you if they have an issue at their house for HVAC repair?
House, commercial. Yes, sir.
And how do you get the commercial business?
Same as the residential. They'll call. They'll ask me questions.
Do you have some regular customers that maybe call you, on an annual basis or regular basis?
Yes, sir. I do. Some very good people.
And you've been doing this for like almost 13 years, you said.
Yes, sir. And again, some very good people.
How much of your business comes from repeat customers, if you know?
20 to 30, depending on the year.
And do you know the balance of that business bank account?
As of right now, that's the account we're talking about. It should be negative.
And do you have any knowledge about what is in your wife's account?
No, it's probably negative too. It was nothing in there. If there's anything in there, it's because of Chris. Chris goes to school.
Now, if you were to be released and Ms. Romanos and Mr. Preciado were to be released, would you guys still live together?
They're my world. That's all I have.
Is that a yes?
Yes, sir.
So y'all would be, wherever you're residing, y'all would be together?
Yes, sir.
So your attorney mentioned your criminal history a little bit. And in fact, do you know the first time you were arrested, what that was for?
I don't remember, sir. I don't remember.
Okay. Do you remember being charged with unauthorized use of a vehicle in August of 1988?
Yeah, I do now.
Okay. And what happened with your case? What was the outcome?
Nothing. Everything's satisfactory.
You're on probation, right?
Yes, sir.
Okay. On that case, do you remember a period of time where you failed to report to the probation department for a period of time?
No, sir. I don't think I ever failed to report. If it was, it would have been the time that I was in the hospital. She kind of wrote me off, but then when I talked to her, we cleared everything up.
So,
in my line of work, there's a lot of work injuries, a lot of work injuries. In my kind of work, you'd be lucky if you get home that night. I mean, it's just industrial work, and it's.
You agree with me though, when you're on probation for a felony charge, it's real important to follow all the rules of probation, right?
I always do. That's why I followed them all correctly, 100%. They're all satisfactory, and then somebody even got commended on my probation officers, all of them. Actually, I even talked to a couple of them. They're real nice people. They're good people, good-hearted people.
So you were placed on 6 years deferred adjudication back in August of 1988. Does that sound about right?
You have to confirm with my lawyer, but I think that's about right.
Okay. And between the period of April to June of 1992, you did not report to probation, correct?
I don't see the numbers. You have the numbers in front of you, sir, so I'm not sure.
You said that was that about when you were sick?
I have no idea, sir. It's way back then. I'm going on 54 years old, sir. I barely remember what I did yesterday.
Wow.
So if you're telling me you're looking at the paperwork and that's what it says, then that's what it says. I'm not looking at the paperwork, you are, sir. So if that's what it says, then I believe what you're telling me.
If the probation department sent in an MTR, motion to revoke, that alleged you weren't reporting during that period of time, would your probation officer be telling the truth?
I don't remember having no MTR, sir. But yes, they would be telling the truth if there was something like that on your paperwork, but I never had no MTR.
And you don't remember having an MTR, but do you remember having to come to court for one, and after you've been a fugitive for a couple months after the NTR was filed?
No, I don't remember. If you have it in front of you, well, you have it in front of you, but I don't remember that. I was, a young kid.
You would agree with me that reporting to a probation officer is very similar to reporting to a pre-trial officer that deals with people that have cases pending, right?
I agree 100%, sir. Yes, sir.
Also,
I'm betting my life on it.
all right. And on that same, around that same time, you were also charged with evading arrest, correct?
Those were all put together. I think you're separating them, but they were all one thing.
Okay, so that was part of the unauthorized use of a vehicle case?
Yeah, there was some things on there, different things, yes, sir.
And then later, in 1994, you were charged with assault bodily injury, correct?
I don't remember the date, but yeah, that's correct.
And what happened with that case?
You have to read it to me, and I'll tell you.
Did you go to jail or did you get probation? Do you remember?
Probably probation, I don't remember.
And then on February of 1999, you were arrested for aggravated assault with a deadly weapon, correct?
That's correct, sir.
All right, and in that case, it was alleged that you stabbed somebody, right?
Yes, sir, you came into the house. I had to do what I had to do.
And you pled guilty to that, correct?
It was the only way to keep me outside and working.
And you were placed on deferred adjudication for 5 years, correct?
Sounds about right, yes, sir. The judge agreed to meet with me that the case should have went my way, that I should have went to court and fought it. But again, I told him that, I needed my livelihood. I have to survive. You know what I mean? So he agreed for me. That's why I only got 5 years. And any judge would tell you should have got about 10, 20 years probation. But he only gave me 5 because he agreed that what had happened was self-defense and I should have taken it to court.
But you entered a plea on that. You took responsibility for that case at the time.
I take responsibility for everything I do, sir.
And you mentioned earlier.
Wonder if that's an indicator of what's going to happen coming up in this
case
trial.
that you had. What was that case for?
Paperwork. That same case, something had happened, and I tried to purchase a weapon. I just signed some paperwork. The guy filled it out for me, and then I got in trouble for it.
So it was for a firearms offense?
I never got the firearm. It was just the guy filled it up. I signed
That's not the charge. I don't even know what happened and all that. But like, this was for unlawful possession of a firearm, correct? What were you charged with? You know.
I was trying to buy a firearm. I never got a firearm. It was just paper I signed.
All right. So something to do with the firearm. And were you sent to federal prison for that offense?
Yes, sir.
Okay. How long did you go to federal prison?
1 year, 1 day.
And then you said after that you were on supervised release for how long? How long were you?
Well, a year, I think. I'm not sure.
Okay.
Maybe less.
Do you remember like the time frame, the year, or anything like that?
No, sir.
Was it after you were on the probation for aggravated assault with a deadly weapon?
I think they kind of ran together.
Okay.
The principal probation officer said that we were doing real good. I was doing real good, so they just kind of ran together. They kind of knew each other, so he said, "Oh no, you're a very good guy. We're gonna just do it like that." So that's how it happened. So how they just ran together.
Okay. Everybody seems to think you're a pretty good guy.
I would tend to agree, except you.
No, your probation officer, you said they would say you're a model probationer and stuff like that.
I've been in this business for 28 years. I know a lot of good people. And let me tell you, I've never done anything wrong. I'm a good guy. You might have a lot of paperwork there, but that doesn't describe a person. That describes a boy. When a man changes who he is, he does things right. Things happen, and you have to deal with it. And here we are dealing with it. But like the judges here, I'm here to do right. And I ain't going nowhere because my family's sitting in Veracon, let me tell you. And we're gonna get through this because that's all I know how to do is survive. And believe me, we will get through this.
Well, in the early 2000s, you weren't a boy, you were in your 30s, right?
A boy in my mind.
Mr. President.
The age doesn't exactly make you a man. Your mentality does. I'm a man now, and I plan to stay that way. And I've been doing that for the last 20 years, 24 years, and I plan to stay like that because I have no other way. When God enters your heart, that's all there is. There is nothing. As long as He be with you, no matter who be against you, and that's just the way it is.
Now, you had talked about your doctor on the outside, Dr. Wynn.
That's correct.
Okay. And
don't ask me what the spelling is. It's kind of weird. It's kind of weird.
that's okay. Now, Dr. Wynn, he's with the University Health System.
That's correct. I think he does other practices too, but university is what we met.
Right. That's where you routinely go for care when you're on the outside.
Yes, sir.
Okay. So, do you know who provides the medical care for you for inmates at the Bexar County Jail?
The same.
It's university, right?
Yes, sir. That doesn't mean you're getting the medications right, because if not, my medications would have debris in them. I wouldn't be getting different milligrams. I wouldn't be sick. I wouldn't be thrown on the floor at 3 o'clock in the morning because my sugar is so low. That doesn't mean you're getting the same people. Just because you're getting the medications, you're not getting the medications you need. That's a big difference. If I sold you a car and I say, oh, just put it in the engine, that's not true. You need to put the engine that the car needs. That's just the way it is. I'm not getting what I need. And yes, I know where I'm at, and I can't be picky, but I still have a right to live. You can't just give me any medication, especially stuff that's already shut down my kidneys. I have a right. You have a right.
And as an inmate at the Bexar County Jail, you were getting you were getting medical care from the same place you were getting it when you were free and out in the world before this.
That's a true statement, but I'm not getting the quality. They're not getting the same medications. If you compare the medications, they're not the same milligrams. They're not the same medicines. You can't compare one brand to another and say, oh yeah, you could say that one. That's not true.
Now, since you've been in the jail, have you been dealing with doctors over there that are in the infirmary?
I've dealt with a few that don't too much listen to me, but I try to. I try to let them know what's going on. They're not they really don't really pay attention. They just want to give you what they want to give you. But again, I've been around for a long time, and you're not gonna just give me what you want.
And aside from, you know that those doctors that are over there at the jail, they actually rotate out from the main university. You know that?
That being said, that has nothing to do with the medication I'm getting. That's not correct.
I've heard what you said with the medication. I'm asking you a simple question. Since you've interacted with these doctors, do you know that they just rotate out from main university?
I do now.
Okay, but so it's not like they're any different than the doctors you get if you went to the emergency room at University Hospital, one of the best hospitals.
I'm not going to the emergency room. I'm dealing with one doctor that I've been dealing with for quite a while.
So, but that's who's taking care of you. And you said you fell. Did you go to the infirmary at that time?
Yes, sir.
Is that the only time you've been at the infirmary since you've been in the jail?
When they've been sending somebody to check on me, and I went, I think, another 2 times. But I have made sick calls. They don't go nowhere. They just tell me, okay, still sitting in the cell.
But you're not in the infirmary unit right now. That's the jail.
No, sir.
You're in the regular unit.
No, sir.
And
well, I wouldn't call it regular. There's nothing regular about it, but yes, sir.
Do you think you're the only inmate at the Bexar County Jail that has issues with diabetes, high blood pressure, and cholesterol?
No, sir. I know for a fact that I'm not.
It's probably something they know how to deal with over there pretty well at this point.
I would tend to disagree with you, sir. Maybe not in my case. Because if you switch to me and you're the one laying on the floor at 3 o'clock in the morning, can't breathe, with your sugar low, sweating, you would think twice right away. You would reverse that, what you just told me. If you were sitting there with holding the back of your head, thinking your eyes are going to pop in your head, thinking you're going to have an aneurysm, you would change your mind.
If it would happen to you when you were in the free roll, you would have gone to university, right?
If that would have happened to me then, I would have talked to Dr. Wayne and would have settled it. But no, he's been taking care of me. I have not had that problem. I have not been holding my head. I have not been thrown on the floor at 3 o'clock in the morning. Where they're just looking at me like, what's going on with me?
Would it satisfy you if Dr. Wynn just talked to your doctors over at the jail about your situation?
It would satisfy me to get the medication I need.
This one's spicy, guys. Spicy, spicy.
I'll pass the word to Sharon.
You can step down, sir.
My son has a little man just like that. Thank you. Thank you, Mr. Rodriguez. I appreciate it. Here, good man. Thank you.
Defense, any other witnesses?
No, Your Honor.
Rest at this time?
Yes, sir.
State?
The state calls Ryan Rodriguez.
This particular courtroom has the added benefit of giving us, so it cut out there. Man. Hang on. That's all we're going to get? Man, we wanted to see the ending of that one. Well, it's not happening. Bummer. I have to go back to Judge Boyd. The end of that one, I believe the victim's mother was arrested, but I don't know what happened. I don't know what happened there. So the victim's mother, who I think was in court, got arrested. Got a phone call from our buddy Ivan. Hold on just 1 second.
Call from
Mr. Ivan.
Hey, Ivan. How you doing, man?
Hey. How are you?
You're live on the air.
How's it going?
What's up?
Oh, I just figured I'd check in between switching cases, that's all.
Mm-hmm.
So we don't get to see the resolution to that.
It cut off. I was just looking for the feed. I can't find a complete feed. That's all we've got. The mom of the pregnant girl gets arrested in the end, and it's reduced. Was the resolution? We need to find the ending if somebody can find it.
The reduced thing is sort of funny to me in the sense that didn't we just hear that he has nothing or nobody has anything? So like unless you reduce it to almost like zero, what good does that do? Like, and by good I mean like in terms of what they're actually asking for, because we all know that bond is 10% of what the actual bond is, right? So right now he needs $60,000, and so let's say they cut it in half, which would be a huge reduction in terms of court. You almost never get that sort of reduction. So does he have $30,000 laying around? You know what I mean? So it sort of seems like
he's got a home that they were gifted that still has a mortgage on it that they say is worth around at least $100,000. I'm not sure if that's equity. $100,000 nowadays is not a lot when it comes to homes.
But if they have a lien after taxes, it's hard to mortgage. You can't exactly sell a home. You have to first square up at the bank, right? And so
you can sell a home. The bank will take their cut.
Okay.
They'll get their money. IRS first, and then the bank.
But then they don't have a home, and so and so it just I don't know, like, and so for people who were wondering, like, can the court, this is like, me and Purple Haze, who has, he has some experience as a correctional counselor. Some people don't realize, because they were like, why doesn't the judge just order that he gets his meds at a certain time? That's not the way it works, okay?
Yeah,
the judge has no control over what happens in the jail.
Yeah.
None. Zero.
Yeah.
The sheriff's department controls the jail, okay? And who is the sheriff, accountable to? Well, the voters, and that's it. The sheriff runs the jail. And so
the judge can give orders for things, but then the jail sort of manages their own system, and so they'll comply as best they can, but they also have their own freedom to operate how they see fit, based on security and manning, staffing, and everything else. So they don't always comply to the letter of what the judge thinks might be appropriate in jail.
And how they see fit. This is when you get your meds in jail. You get them when you wake up at 5 o'clock. You get them at your 3 meals, and then you get them before bed. And that might not always be, conducive to whatever your ailment requires. But that's what you're going to get, unless you start going into like a, after like a shock, or you go into some like sort of emergency situation, and then they, usually, send you out for a minute or two. But as far as the judge cannot order a regimen, is what I'm getting at here. He can say, you guys should probably do this, but based on staffing and availability and just the way they run their jail, you got to remember there's hundreds of other guys in there getting meds too. And so they put a system in play where you get them before your meals and you get them before bed. And that's when you get your meds. And unfortunately, not every med is designed to be given that way on a timetable, but that's just how it is. And so it's, not that I'm feeling sorry for him, but this is the other side of it. I mean, is it cruel? Is it inhumane? It might be, but boy, like, we can make a list of things that are cruel and inhumane within the system. And so it's hard to shed a tear, but it's also, just kind of part of how it goes. So,
yeah,
but
I hear you.
I just wanted to add some clarity to that for people who are asking, just why can't the judge just tell them to get them at this time, this time, this time? Well, you have hundreds, thousands sometimes of guys in jails. Most of them are on meds. You have a limited amount of staff, correctional officers, and they develop a system that works for them.
And for security, they can't just open all the doors and say, "Come and get your drugs," right? They're just out one at a time through the pie hole, right? Through the pie flap.
Yeah, we used to call it Skittle time. Come get your Skittles. And so you just have to work a system that works best for the mass amount of people that you're having to dispense meds to. So
awesome.
Anyway,
thanks for the insight, Ivan. Appreciate that.
Yeah, love you guys.
Love it. Bye.
Bye.
I just barely missed a call. Courtney, I think the link you sent me is not a clean feed. It's not a clean feed, so I haven't been able to use that one. It's a news report. Mary Kay gifted 5 memberships. Thank you, Mary Kay, for that. So the total bonds is now down to $450,000 for him. Let's see. Call him back. Let's see.
Call from Nosy Rosie.
Hey, Nosy Rosie. How are you doing?
I'm doing good. How are you?
I'm doing great. Happy Tuesday.
Happy Tuesday, yes. So when I called yesterday and I was off topic, it is actually on topic today. Yes.
So I don't have to push the not relevant button?
Yes. No, I'm relevant today.
Talking about stuff that is not relevant.
Okay, now what's up?
Dang, that's harsh. So Matthew's dad did an interview the other day, and he was talking about how he's been in touch with the DA and how the defendants were going to be going in for a reduced bail bond hearing. And he was, kind of confused about that, and especially because they were court-appointed attorneys. But then he said, and I can't remember if he said that the DAs told him who the small player bail bondsmen were and to not worry about them, and which ones would be the ones to handle a big bond like the Preciados. And so then Matthew's dad said that he was going to go talk to them. And in the same breath, he said, but I'm not going to intimidate them. And I'm like, I'm not a fan of the Preciados at all. In fact, hearing Ramon's hearing today just really triggered me. I had to leave for quite a bit yesterday and today. So I'm not a fan.
Right.
Let me start by saying that. But I'm not a fan of what seems to me like possible intimidation. It's like saying he's going to go talk to possible defense attorneys. And I don't know if it's in the same realm.
So
I didn't like it.
I've thought about this a little bit since you talked to me, and I've read a couple comments in chat, and I agree with some of them. Matthew is a victim. His dad is just a person, an individual, and the bail bond companies are just corporations. They're businesses. There is nothing. I mean, if intimidating, threatening someone, that would be a problem. Saying if you do this, then we will. I mean, you better watch your back. That would be illegal. But he can go there and say, look, they killed my son. Okay, they killed his girlfriend. Unborn baby, 9 months pregnant. Please don't do business with them. We would. Please. Now, that would be his right to do that, and he could do that and say that, and he could go protest or walk him down with a sign in front of the business and say these people are bonding out murderers. Well, right now, under the law, they're innocent until proven guilty, and they have not been proven guilty. So he has to be careful what he says about the Preciados, because they have not been convicted yet. But him going to a business and even getting his friends or, writing to the newspaper saying, please, write all the bail bondsmen. We don't want these people out on the street. He can say that. He just has to be careful so he doesn't cross the line and get sued by the family that he's fighting against for libel or slander or something like that.
Right. And not to mention that the families don't even have any money to bond out anyway. So.
Yeah. Oops. I've got an unstable network.
Ivan was saying, there's no money.
Yeah.
Someone in a chat room in Facebook was saying, "Oh, they're going to run to Mexico," and I was like, "No," because clearly we're not dealing with the sharpest tools in the tool shed. Because I expected them to be in Mexico. They were chilling at home. So
yeah, he says he's never been to Mexico. He's a U.S. citizen. He doesn't have family there. He doesn't have a passport. Doesn't have a reason to go to Mexico. He says he's always faced his challenges head on. He's a man now. He was a boy when he was 30, but now he's a man. And I'm curious if that means that we're going to see a guilty plea. That would be interesting. But
doesn't he have to be offered a plea in order to plead guilty?
No, he can plead to the charges. Now, a plea deal might be something where the prosecutor comes to him and says, "Look, you're charged with X, Y, Z. We would drop this charge and lessen this one if you just plead guilty." That would be a plea deal, and that has to be offered to him. You don't necessarily get one for sure, but he'll have an opportunity to plead. And right now, I think it's not guilty is what's been entered on his behalf. But he has an offer to change that to guilty if he chooses to do that.
Yeah. Well, these people have nowhere to go if they bond out. They have no money, and it's such a big case here in San Antonio. There's a ton of people that would be watching him the second he got out, or they got out, or whatever.
It wouldn't be safe for him.
It wouldn't. I literally wrote that in a thing last night. They are safer where they are right now. They don't have a life outside of the people that the victims hung around with would not let this go easily. And I'm not saying they're bad people. I'm just saying there
was a criminal element to that environment.
100%. And they're not going to let this go. There was a baby and all of that stuff. Yeah. So anyways, I was just wondering about that. And so thank you for your insight.
Yep.
And
thank you. Thanks for keeping it relevant this morning. That's awesome. Nosy Rosie. Appreciate that. Yeah, this is thank you very much. This is one we're going to follow. Nosy Rosie, thanks for the updates and thanks for the information. Appreciate that. Bye.
Bye.
We are going to follow this one and see what happens. I don't know. I mean, we've got a son, a mom, and a dad who are all implicated in this crime in one way or another. I don't know if there will be any charges as from what happened in court that we missed. The mom of one of the victims, I think it was Savannah's mom. I'm not sure if it was an assault or what happened there. I don't know why she was arrested. So maybe if somebody could fill me in, that would be good.
Bree.
Hey, Bree, how are you doing today?
Good. How are you?
Doing great. What's up?
Really quick. So mom was picked up for, hold on, where did it go? I just sent you the article. She had a previous incident for failing to stop and give information. So it was like basically a traffic warrant, and they saw her in the crowd, so they took her.
Oh, so it wasn't like an outburst in court. I was thinking it was going to be something spicy with like a, hey, you killed my child, type of thing, and like attack. We've seen that before as well, but just on an existing warrant.
I sent you the article. I sent you the article to your DM as well, so you have it.
Was that on
Twitter?
Oh, on Twitter. I have not checked Twitter yet today. I'm like, I did not see it anywhere. I saw the message, but all right. Okay, I'll check that. Thank you, Bree. Appreciate that.
You're welcome.
She'll probably be let out pretty quickly on that, I'm guessing.
Yeah, I'm
Court
sure.
appearance, she'll be out. So
all right. Talk to you later, guys.
Thank you.
Bye.
Bye. All right. I don't know when this one will actually go to trial, and I also don't know if I don't think they're being charged together. Because the husband and wife might be charged together. I'm not sure if they're going to join those two trials and have it be one, or if they're all going to be three separate. But I think the son might have committed the murders separate and then elicited the help of his parents. That's my take on it. So they might be separate at least in two trials. Got to watch the trial if live streamed. I think it will be because it is in San Antonio, Texas. It's in Bexar County, which is very friendly to media in the courtroom. Extremely friendly. He's a good guy. He says he's a good guy. And to his credit, I mean, I have a hard time believing some of what I heard from him. First of all, I know how much HVAC guys charge, especially in hot, humid climates where heat is literally a safety concern during the summer. If he's working in that field, and he has been for 13 years, has his own business in that field, that's some good money. There's some good money there. It's a very in-demand business that just seems to always, as you have more houses being built, there's just the demand seems to outweigh the supply, and that drives the cost of those services pretty high. So when he describes this as basically living paycheck to paycheck, that didn't ring true with what my personal experience with HVAC industry as a whole. He described HVAC like a war zone. Yes, he's like, it's you're lucky to get home alive at the end of the day. We should get hazard pay for what we do. May not have used his money wisely. What evidence do they have against him? Video of him and the vehicle with the bodies in it being, I think, put in drive and driven into a ditch or something. I don't know what exactly happened, and a towel wiping things off. Yeah, trying to hide the bodies. My hubby's a commercial electrician in Central Florida. That can be a war zone, says Melissa P. All right, let's jump back to Judge Boyd, who's now back with us. Let's see what's up here.
With Jason Garahan about this defendant, about the two cases, and we've sort of agreed that Mr. Brown is going to do several classes and some stuff up front as we work towards a resolution. So we're just asking the court for more time to give Mr. Brown time to get those classes.
All right, what are the classes and how long are you estimating the classes will take?
A DWI intervention class. I believe there was a drug offender education program class. I know at least those two things, Your Honor.
All right, so this is going to have to be taken care of before Fiesta, because Fiesta is
party,
alcohol.
Right.
On.
Yes, ma'am.
Attorney Cameron Diaz.
I mean, if the court, I'm not sure when Fiesta is.
No, I mean, what I'll do is Fiesta, they've extended it to the entire month of April. But what I'll do is I'll recall this. I can recall this for April 4th. Ms. Abrams, can you come forward? This is Stefan Brown.
Oh, it's on a charger.
All right, on this case, it's not set today, but, all right, so they're asking if this could be recalled on a different date because the state wants him to do certain classes. And the DWI that's in it, they don't have the discovery for that yet. So it seems like
phone is
things
like
may
on a
work out
shoulder
if he
strap,
completes
right?
all of his courses. So I wanted her before Fiesta gets into the full swing of things. So April 4th. All right.
Yes, ma'am. Thank you, Judge.
You're welcome.
All right, have a good day.
You too.
Yeah, that's her phone on like a shoulder strap. I've never
Yes.
I've seen purses worn that way, but never a phone. That's interesting. It's just a clip. I guess she probably uses
Norma,
it all the time.
This
It's a
case
hassle
is not
taking
on the
it in and out of
docket
your
today,
pocket.
but it's been recalled for April 4th.
It's useful. Hello, good sir. Microphone's off for a little bit. Carolyn says, I think it was more like a Paris Hilton than a Cameron Diaz. The flowers today were beautiful, as was the purse. Fiesta is done as a remembrance of those who fought at the Alamo and Battle of San Jacinto. A huge event, says Amanda H. So this is the Remember the Alamo. How is it celebrated? I assume a lot of drinking.
Okay.
Yeah, there are reenactments and all that.
Hi, how's it going?
Good. Stopping by, see how you're doing.
Oh, everything is going great. It's Tuesday. It's not Monday. Hopefully no one tries to make it out of Monday.
Actually, I was stopping by. Yeah. Is there some time this week where the courtroom would be available for about 45 minutes to an hour?
Perhaps Friday.
Friday?
Yes. Fridays and Wednesdays are usually best for us.
What are you shooting a
You
video?
just swap out that printer?
Yes.
And they said it'll take about 45 minutes to an hour. 'Cause I got
Well, let me ask you, are they able to do it over the lunch break or no?
that, because they go to lunch also at that time.
Yeah,
So
no, I
that's
understand.
one big part of the problem with that. So I was like, well, let me find out when they're free.
Friday would probably be best. I tell you what, if they are able to come on Friday, what time would they be able to come Friday morning?
Friday morning, get in there is 8:00.
Okay, so we can change it on Friday morning at 8, and I'll push off the trial if we're in trial to later in the day.
Yes, her microphone is on now.
Awesome.
Much better.
Yes, everything is going great.
If you need anything, you know how to get a hold of me.
Yes. All right. Thank you so much. All right. Thank you. Oh, you know what? If they want to come on Wednesday too, they can.
Wednesday in the morning,
Yes.
tomorrow?
Yes. So
Hump
if
day?
Wednesday morning is doable at 8,
So Wednesday at 8 or Friday at 8?
either one,
Okay,
just let me know.
okay. I'll let Deshawn know.
All right. Thank you. Macy
So-
Malone.
While the judge is waiting for this trial, let me just tell you, I got an
Who's here?
email.
Macy Malone.
He's still downstairs.
Okay.
I got an email from a company wanting to do a team up with me.
All right. Thank you.
And I've had a couple, and I have
Leonardo
not
Carlos.
accepted any of them because I'm picky. I'm not trying to sell my soul for whatever company's out there. But
All right. Is this family violence case?
okay, we're gonna bail.
We have one of each.
Okay.
Family violence and DWI.
There should be 2 files for Leonardo Carlos.
I had to do one.
Yes.
And then I said, oh, here's his companion case.
Okay, let me tell you this story.
I mean,
or
does he have 2
I'll tell
different
you
names?
after. I'll tell you after. I want to tell you the story.
Yes.
Seeing some things good.
Oh, this is a plea.
That is
Okay,
a
I'm
very
sorry.
That is a very red shirt.
No problem. All right, if you guys will have a seat, the court reporter is just taking a brief break, and then we'll take it up. No problem.
He's on Central Time, right? So he's got another hour, an hour of sitting in the courtroom. And if he gets up a minute early, the judge is going to be like, eh. Okay, so let me, while they're doing this, let me tell you the story, right? we'll go here. I'll be on screen for this one. So I get an email from a company that says, we'd like to, hey, Recovery Addicts, your channel is wonderful. We recently discovered you. We think we'd be a good fit. We'd like to team up. We'd like you to do a 60-second advertisement for our company. We'd like the ad to be at the beginning or the middle of your live stream, and we'll pay you $10,000. And the story sounds great. It sounds wonderful, and it's legit. It's legitimate. Here's my issue. Okay, I volunteer as tribute. Here's my issue. The company is a computer game company. They want me to advertise a computer game, and I have to look at this. Have you not watched the show? Have you not? Recovery Addict. I am literally in recovery from computer gaming, and you want me to advertise your computer game? I won't sell my soul like that. I will not do it. Oh my goodness. You guys are like, for 10 grand, I'll advertise anything. Honestly, it means more to me that the money would be very helpful, but no. So it's like, I appreciate it. Maybe an ad might come down the line. I mean, I'm always looking for that ad from Deer Park Water, where they're like, hey, how does a year's supply of water sound? And I'll be like, where do I sign? Right? Where do I sign? But yeah, this company, it's a first person shooter game. It's like, first of all, there are some of this community that enjoy games, and that is wonderful. That is great. Most of us, not so much, right? Or we don't anymore. But anyway, yeah, I'm staying true. I just thought I'd tell you. That's why this is the only time you'll hear of that. But the product has to align with the values, has to align with our community. John's like, sell it. Can you imagine? Oh man. For when you're not watching true crime, how about you commit some in this computer game? No, I don't know how I could look you in the eye after doing that. I was like, take the deal. No. Anyway, I thought I'd share. I'm pretty sure I'm like, just by telling you about that, other companies will not reach out to me. But I didn't say who they were. I didn't out them. But I mean, honestly, I'm all for companies doing well, right? For making some money, for advertising, reaching out to clients. That is great. That's great with that. But read the room a little bit. Read the room. That's all I say. I literally, my story of how I got here, of why I chose this name, of what it means to me, is the opposite of what you want me to sell. So anyway, so still no ads. Ivan's like, well, what if we added a 0? Ivan, I'll tell you the truth. I would like to think that there are no amount of zeros that make it right. Because I'd have to look at myself in the mirror at the end of the day. And if I can't feel good about what I'm producing and what I'm saying and what I'm putting out there, what good is that? I mean, have a fat bank account and hate yourself. I couldn't do that. Anyway, that was it. Let's go back to Judge Boyd. That's the end of the story.
The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, sir.
Did you understand by entering this plea you were giving up those rights?
Yes, sir.
Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yeah.
Mr. Carlos, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
Anyone promised you anything other than the plea?
no.
Satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $500 fine. State recommends community supervision. This will run concurrent with County Court Cause number 710098, 71099. Take in consideration 2023 CR 6643. County Court Cause number 713955, 713958. Ignition interlock for half the term, victim impact panel, and DWI intervention. Did you understand that to be your plea?
Yes, Your Honor.
Defense, is that the plea?
The plea includes an option of either 10 years jail, 10 days jail.
That's outside the plea bargain agreement.
It's in our plea bargain.
No, it's outside.
It is part of our plea bargain.
What I'm telling you, counsel, is this is your plea bargain agreement. This is outside the agreement.
Well, it is my understanding it's part of our plea bargain.
All right, I'm telling everybody it's not a part of the plea bargain agreement. Note, this is what it reads. Note, the parties are not allowed to make binding agreements regarding the length of community supervision or the terms and condition of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea bargain agreement. However, the state or both parties make the following non-binding recommendations. And what it says is 5 years community supervision, TAP evaluation, 120 hours of community service restitutions, 2-year driver's license suspension, 10 days house arrest in lieu of 10 days Bexar County jail. That's not a part of your plea bargain agreement. You all can present that to me and I can either follow it or not follow it, but that's not a part of the plea.
Is the 5 years probation part of our?
No, it is not. The court determines the length of the probation.
And if you reject that 5 years, then it's a rejection of the plea bargain agreement.
No, if I don't follow your length or your suggestion for the length of probation and I give you, let's say I were to give you 8 years on probation or 4 years on probation, that's not a part of your plea bargain agreement. And I have not violated your plea bargain agreement because the court determines the length of probation, not attorneys.
Then Judge, I think we can't go forward with this because our understanding of what a plea bargain agreement differs.
All right. Well, what I'm telling you all, according to the law, you cannot come before the court and tell the court, I want to be on probation for 5 years only. Y'all are not allowed to enter that agreement, period.
Now, Judge, you do not have to follow that agreement. That is correct.
That is not a part of your plea bargain agreement, counsel. The court decides the length of probation that somebody is on. The attorneys do not. The attorneys just make a suggestion. I'm going to read it again. Note, the parties are not allowed to make binding agreements regarding the length of community supervision or the terms and conditions of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea bargain agreement.
Is probation part of the agreement?
Yes, they're recommending probation. Now, if, for example, if I were to say, okay, you guys have agreed that he's to have probation and I say I'm not giving you probation, then I will have violated your plea bargain agreement. But the length of time, the conditions, that's completely up to me. You all can't enter into a plea bargain agreement telling the court what your conditions will be.
That is not my understanding of the practice in this county.
Well, if people are practicing that different in this county, and I don't want to be mean to anybody, but if people are practicing that differently, then they are practicing the law incorrectly because the court decides the length of probation. Nobody else does. Defense attorneys don't decide the length of probation. The state doesn't decide the length of probation. The court does. Nobody else does.
Well, I guess my concern is moot at this point unless you do not follow our agreement.
Well, the question becomes, what do y'all think you have agreed to? Because if you think you've agreed to how long he's going to be on probation, that's not a part of your agreement. So if you all want to reread your contract, you're more than welcome to reread the contract. If you all want to go forward, you can go forward.
Well, Judge, I guess I need to review that comment
Sure.
and we'll come back to it.
All right. And State, if you want to show him.
Wow.
Words based on the court's understanding.
No, based upon, I mean,
the law.
Based upon the law.
Yeah.
Counsels do not get to determine the length of probation or the conditions of probation. That's not my understanding. That's the law. If people want to get that law changed, they need to talk to the legislature.
Well, it's been my understanding and the practice in this county that the judges allow us to do that.
Well, I don't want to disparage any judge, but guess what? They're wrong. Because according to the law, according to that document that y'all just signed, the court determines the length of probation. Nobody else determines the length of probation. The court does. So if the state is asking for 8 years probation as the length, I can say, you know what? I've read the facts of this case. I think the person should only be on probation for 4 years or 3 years. That's up to me. Or the state may say, me and the defense counsel believe the person should be on probation for 5 years. I may read it and think, no, that person should be on probation for more than 5 years. I'm allowed to do that. And guess what? That is not going against the plea bargain agreement that you've entered to. So if y'all want to discuss that, you can. But if other judges are saying, oh, the law is that's the plea bargain agreement, then those judges will be wrong. All right. Yes.
I'm not ready to go forward with it then.
Then we'll be in jury trial. All right. Macy Malone.
Present.
All right. So did they give you, and if you want to hand that back.
He's like, I guess we're done.
So jury trial is at 1:30.
He doesn't want to be done.
And you can put that in here. All right.
Well,
Macy.
we're announcing not ready on the trial because we were expecting
Oh, you all need to file a motion. I'll hear it and make a ruling on it.
Okay.
All right. Macy Malone, where are we on this case?
Your Honor, I went over to Credit Court in person, and basically we should get a setting within the next few weeks. I'm asking for 30 days so we can hold the competency hearing in his court and come back with the results.
Okay. All right. Ms. Ferguson, on this case, can you put it at the end of March, please?
Thank you. And she's been advised of the whole process.
All right. Do you have any questions about anything?
No, ma'am.
All right. Thank you. All right. We're going to call it back on March 28th then.
March 28th, I'm in federal court in Del Rio. Can we do the following day?
We can do it on the 26th.
The 26th is a Tuesday?
Yes.
Yes.
All right. So we'll be back on March 26th.
Thank you. Maybe excuse Your Honor.
Yes. Ms. Malone, we'll be
I
back
wonder-
on March 26th, but if things take
We
place
missed
sooner than that, your attorney
missed
can
the
always
first
come
part
back
of
and
that.
get an earlier date, okay?
Of that appearance before the
You're
judge.
welcome.
It may be the facts of the case. I think there was a domestic issue, family violence issue, and a DUI in the same batch there. And it may be the facts of the case that the judge thought that the deal was a little light on that. But as she read the law on the terms of the plea agreement, I think she's in the right, even though traditionally we're used to a deal being agreed to and the judge rubber stamping it.
What's that? For the client, did you want me to find him?
Yeah, if he wants it, yes. If he doesn't,
If I had to go next,
go to somebody on the
anything you
list.
can do to push this off, even though I have to wait in jail another 30 days,
Yes.
it's not, you don't want to be the next person up because the judge has warmed up her swing and she is still at bat.
It's Tuesday.
The trial's going to be at 1. He's going to announce not ready. He's going to have a motion prepared. I think the judge will hear it because it's the lawyer's fault, but it ends up screwing the defendant. The lawyer told the defendant most likely, here's what's going to happen.
Tell them,
The
you know,
defendant made a decision
1:15 because
based
it'll
on
take them that
and the
long to
lawyer was
line them
wrong.
up.
So I bet the motion, if the lawyer admits that he counseled his client incorrectly or didn't understand something, I bet the judge is going to grant the motion, grant the delay. I don't know. She doesn't like pushing that out. She doesn't like. I mean, there's a plea deadline and she wants to hold that. So maybe she'll force him
And
into
Norma,
trial.
if you'll call Anthony Cantrell.
Yes, he's like,
All right, thank you.
Yeah, the guy with the attorney, the guy in the red shirt, is the judge talking. He's nodding. He's like, "I agree, Judge.
Nicole
You're right.
Villarreal?
I'm not with stupid." Oh man. Everyone's like, "Don't call my case. Don't call my case. Don't call my case." Someone deliver flowers quickly. Jackie, we saw one of these earlier. We saw this morning a guy saying, "I'd like to have my lawyer withdraw from the case and take a public defender instead." The judge will do that, but she's not going to change the deadline. So to trial they go. How would you like to be an attorney who gets assigned to a case the day before trial? That just seems not fair. FTD stat. Yes. We need those flowers.
All right, I have the file on Lee Galindo. Why do I have this back? Oh, you're Lee Galindo? Okay, thank you. All right, Lee Galindo. How's it going?
It's going, Judge. It's been very busy last couple of days.
Why has it been so busy?
Trial settings.
All right, court is calling 2023 CR 6947. And Daniel, I know you're by yourself. Could someone take the plea? All right, thank you. All right, could I have the parties announced for the record for the state?
Anna Ochoa Nelson.
For the defense?
Brent Alabastro, Mr. Galindo.
And are you Mr. Galindo?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Galindo, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We're going to waive and abandon the repeater enhancement application.
Any objection?
No objection.
To waive the enhancement, yeah, no objection from
Mr.
defense.
Galindo, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with driving while intoxicated, third or more? That's a third-degree felony.
Ooh.
Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Galindo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 5 years in the prison, and the state is silent on your application. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the offense charge, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
He said
State
guilty.
offer states it's a good one with attachments.
We have reviewed it, Your Honor. No objections.
All right, and state, you may continue to confer.
Thank you.
Thank you. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
We have a case coming up February 26th with Robert Crimo, July 4th parade shooting in Illinois. He's going pro se. I think that's our next big one that's coming up. We might have some small ones until then. Always possible to have some hearings and some cases like the Corey Richards, Brian Koberger, Sarah Boone. I think there might be a Sarah Boone letter soon. Might have to keep our eye out for that one. I'm sure she's got a new lawyer, has something to say about that.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. This will come back on sentencing. We need a PSI and TAP evaluation, Ms. Ferguson. Yes.
He's applied for community service. Like he wants parole. Is that what? It's his third DUI. There's no way she's just going to let him out on.
All right, we're going to come back on April 9th. Probation, I'm going to also want a referral to felony drug court. So we're going to come back on April 9th. At that time, I'll make a decision on your application based upon the PSI report, TAP evaluation, whether or not you're accepted in felony drug court, and any other evidence that's presented to the court. Do you have any questions?
No.
All right, make sure you make all of those appointments. Do not miss any of them. Do not miss the appointment with felony drug court. You understand?
Yes, ma'am.
All right, is there anything else, counsel?
No, Your Honor.
All right, once you sign the reset form, you're excused.
Thank you, Your Honor.
You're welcome.
Third offense DUI. That he's probably going to get some time. I'm not sure how much he's served already, but 45 more minutes for our friend in the white hoodie who was late to court and was ordered to stay until noon. The judge is keeping an eye on him. He has not budged. And Lee and Shells, to our good friends from the channel, from the community here, and previous court watchers are attending that one. I'm not sure if they're there every day, but they have been attending the Adam Montgomery trial. Lee and Shells have. Treehouse murder rescheduled for March 3rd, March 7th. I don't know. I'm not sure if the new judge is going to have to reschedule it, because the new judge, when he takes the case, will have to fit it into his schedule. So there might be some adjustment going on there.
Yes.
There's the beautiful yellow bow tie. Let's see if we've got some other courts that might be coming available to us as well. I'll do a quick check. Ooh, Thurston County District 4. Whoa, what have we here? Thurston County, are you delivering the goods? Do we have the goods? Yes, we do. I'm not sure what's happening, but we love Thurston County, so we're gonna bail on this and jump to them.
Mr. Sanders, I see you on camera. Are you ready on something?
Yes, Your Honor. Mr. Keontae Coleman is with us this morning. We have a change of plea to an amended charge this morning.
All right. Good morning, Mr. Coleman. Can you hear us okay? Looks like you're connecting to audio. I'll give you a moment here.
Looks like military is my guess there.
And Mr. Coleman was one of the pleas that I had signed and ready to go for you.
All right. And I'm not seeing that in the judge's folder. Is that?
SoCo SLP. I've got like 7 different Sarah Boone lawyer songs, and I've read them all. They're wonderful, every single one.
See JNS in there.
I'm not sure if we're gonna go, or I'm not sure if any of them are ready for like recording. But the rare over-the-shoulder appearance
the JNS, though, right?
in Zoom. That's
Right. Oh, you want the, oops, sorry.
All right, Mr. Coleman, can you hear us okay?
Yes. Yes, Your Honor.
All right. All right, Mr. Sanders, do you want to make any further record before I inquire of your client?
Yes, sir. I've reviewed a statement of defendant on plea of guilty on a 1-count amended charge, neg 1, reviewed his rights that he'll be waiving by proceeding by way of the plea, prosecutor's recommendation, and that the judge will have the ultimate authority as to sentencing. No immigration issues that we need to touch on. I believe the court will already have had an assessment ADS and victims panel file.
All right, thank you, Mr. Sanders. All right, Mr. Coleman, I'm going to go through this document with you. It's going to take a couple of minutes because there's a number of pages here. I want to make sure that you understand everything. Did you hear what Mr. Sanders just made a record of to the court?
Yes, Your Honor.
Did you anything that you heard that you disagreed with there?
No, Your Honor.
All right. Is your true full name Keontae Dreshawn Coleman?
Yes.
Are you 27 years of age?
29.
29, okay. And do you read and write the English language okay?
Yes.
The reason I'm asking you that is because this form is in English. And did you go through this form with your attorney? Did you read it yourself? Did he read it to you? Or was it sort of a combination of both those things?
The combination of both, Your Honor.
All right.
And
he mentioned that he went over the rights with you that you're giving up here. Do you have any questions about your trial rights that you're giving up by entering into a plea today?
No, Your Honor.
Also talked about going through with you the recommendation here, and I'm going to read this recommendation to you, and it is a recommendation from the prosecutor that the court should impose 90 days, but to suspend all that time, to impose a $1,000 fine, but to suspend all that, $250 BAC fee, another $102.50 in costs, $43 conviction fee, 12 months of a suspended sentence, no driving without a valid license, alcohol evaluation and follow-up, no refusal of a breath test or a blood test, no BAC of greater than or equal to a 0.08 or 5 nanograms of THC, no driving without a valid license and insurance, to attend a DUI victim impact panel, to comply with Department of Licensing on the ignition interlock, and also to not frequent bars or taverns, and no consumption of alcohol or non-prescribed controlled substances.
And Your Honor, if I could just briefly.
Yes.
So the recommendations is an agreed recommendation. The only addition that I did is the one that's in pen there, that's specifically no consumption of alcohol and non-prescribed medications. I don't believe that that's an issue here, but I just wanted to flag that for the court because I didn't discuss that with defense counsel before writing it in.
All right, thank you. Defense counsel, any comment on that addition?
No objection, Your Honor.
Okay. All right. Mr. Coleman, your attorney indicated that you understand that this is only a recommendation, that the court could impose up to that maximum sentence. Do you have any questions about that?
No, I don't, Your Honor.
And your attorney also indicated that immigration consequences were addressed with you, and that's not an issue to further discuss. Do you have any questions about your immigration rights?
No, Your Honor.
There's a paragraph here that asks you to state in your own words what it is that makes you guilty of this crime. And what's typed out here, I'll read to you, and I'll ask if you if this is a true and correct statement, and if you're adopting it as your statement. What it says is, I drove a vehicle in Thurston County, state of Washington on October 28th, 2023, in a negligent manner likely to endanger property while exhibiting the effects of having consumed liquor. I drove at a speed above the posted speed limit. I had consumed alcohol earlier in the evening. Is that a true and correct statement?
Yes, Your Honor.
Are you adopting that as your own statement today?
Yes, Your Honor.
Anybody made any threats to get you to plead guilty to this charge?
No, Your Honor.
Anybody promise you anything other than the recommendation by the prosecutor?
No, Your Honor.
What is your plea to the charge of negligent driving in the first degree? Guilty or not guilty?
Guilty.
All right. I will accept your plea of guilty. I do find that's being made knowingly, intelligently, and voluntarily. I also find that there is a factual basis for the plea. So we will move on to sentencing. I'll hear from the state first if they have anything to say, and then I will hear from your attorney and then from you if you have something from the state.
Your Honor, I would just ask the court to follow the recommendation. It's a agreed upon recommendation. It was negotiated by myself and defense counsel, and our office believes that it is a just resolution to this matter.
All right. Thank you, Mr. Sanders.
And yes, Your Honor, you'll see from the court files, it was a low breath test. Keontae is active duty military infantry at JBLM. He was out on maneuvers at work until 11 p.m. last night, so he's serving his country admirably as an infantry. And so we'd ask the court to look at the financials, give him whatever the court can in the way of giving him a break on what he'd have to pay financially, given he's active duty military. He's done everything, been very proactive, followed everything, and it's been a pleasure to represent.
All right, thank you. All right, Mr. Coleman, you have a constitutional right
stand
to
behind
address
the
the
attorney
court
here.
at sentencing. You don't have to say anything, but you have a right to. And if you want me to know anything, this is your chance. Anything you want me to know before I impose sentence?
No, Your Honor.
All right. Well, I will. I've looked at your criminal history here. This is the only thing that appears on it. I do see there's an infraction that is tracking with this as well, so we can address that in just a moment. With regard to your sentence on the negligent driving, I will follow the agreed recommendation here. I will impose 90 days. I'll suspend all of that time, and I'll impose all the alcohol related restrictions.
And Your Honor, just addressing the infraction, I don't believe defense counsel or I discussed how to handle the infraction. Given that our office didn't take a position one way or the other on it, and in the spirit of closing out the case pursuant to the plea agreement, the state would ask for the infraction to be dismissed.
Ooh, that's
all right.
nice.
I assume there's no objection by defense on that.
Just nod and smile.
That will be the order of the court. Then we'll dismiss the infraction as tracking given the entry of the plea today. Mr. Sanders, how long does your client need to get the DUI victim impact panel and the substance abuse assessment?
He's completed all those requirements, Your Honor. Assessment, ADIS, and victim.
Okay, thank you.
Does the court have those? I know that defense counsel sent me a copy of them, but just okay.
You do. Okay. Perfect. All right, so I won't be imposing any probation fee given the fact that you've already completed all of those, and I will impose the conviction fee of $43, but I won't impose any other legal financial obligations at this time.
He got off pretty lightly. Need to find a plug that's fallen behind my desk. Hang on a second.
All right, I am signing that judgment and sentence. All right, Mr. Coleman, good luck to you, sir. Thank you, Mr. Sanders.
Okay, I found the cord. I plugged it in. But I also want to.
And yeah, could I just again have a quick summary of the sentence? Essentially, filed the recommendation short of the fines. It's $43 total.
Yes, correct.
Thank you very much. Thank you. Thank you, Counselor.
Dawson. I was 22-year-old mechanic.
Let's go in
Ms.
there.
Winiger, are you ready on something?
I am. Good morning, Your Honor. I'm here for the Shane Diamond matter.
Okay.
And Your Honor, this is a matter that we're still waiting for the blood test result. I confirmed that with the state yesterday. They're potentially anticipating it in April, but their guess is probably as good as mine. So we would like that piece of evidence as we continue to work through this case. So we are asking for a more lengthy continuance to get us to April, just to see if we're able to get that blood test result back in the toxicology lab.
State, what is your anticipation or what's your estimation of when that will be completed?
Let me take a look at the file, Your Honor. My understanding is that this incident
I found
took
a new
place
trial
on-
that we might be able to watch, or at least it's a Supreme Court hearing in North Carolina that's going on right now. We've never done any Supreme Court hearings before. Are you guys interested in taking a peek?
Oh, trial that's already been set, so we need to move the trial date.
Yeah.
Yeah, this is a date of incident of 6/2 of 23.
Yeah. So given the tox lab has taken upwards of 8 months to a year, I don't know if they've worked through the backlog that they've been dealing with, but it can take a while for us to get tox results back.
Okay, so I think that's just another DUI. So we're going to jump over here to.
What our office has been doing is just agreeing to continuances to the extent that defense wants continuances, and then trying to resolve without it. But I don't know that.
Okay. Now, this is a Supreme Court hearing. I'm trying to see the case, but now I can't see it anymore. So I don't know what it is. They'll announce it here in just a minute. But a Supreme Court hearing in North Carolina. We'll have 7 justices up there, and it will be basically when your case gets appealed all the way up to the Supreme Court. This is how it goes down, and we've never watched that before. So we're gonna jump here. Give us just a minute. I'm trying to get caught up. We're a couple minutes behind what happened here, but there it is.
The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Wow. Okay, let's see if we can get the audio fixed. God save the state and this honorable court, he said. I don't know what he said before that one.
Good afternoon.
Oh, yes, oh, yes, oh, yes. I'm not sure.
Our next case is State versus Dahl, and we will hear from the appellant.
Man, they're quiet. We're gonna crank this one up.
Good morning. May it please the court, my name is Heidi Williams. I'm here from the North Carolina Department of Justice, and I represent the state in this matter. I'd like to reserve 5 minutes for rebuttal. In this case, the state asks this court to clarify the scope of relief available to criminal defendants pursuing post-conviction relief by filing a petition seeking the writ of habeas corpus. For well over a century, this court has held that when a defendant is imprisoned pursuant to a valid final judgment entered by a court of competent jurisdiction, the state privilege of habeas corpus provides no mechanism for the person detained to complain. An exception to this rule exists, this court has held, when a defendant asserts that the court imposing the final judgment either lacked jurisdiction to impose it or acted in excess of its jurisdiction. Yet here, a defendant has never alleged that the superior court either lacked jurisdiction or acted in excess of its jurisdiction when it entered final judgment against him and imposed the sentences under which he was being held. Despite this court's consistent opinions defining the scope of the rights available under the state privilege of habeas corpus, in a string of modern opinions from the Court of Appeals, all involving defendants convicted of crimes and incarcerated by virtue of valid final judgments, the Court of Appeals has cited NCGS Section 1733 sub 2 of our State Habeas Corpus Act as though this provision applies and as though habeas corpus exists as a viable avenue for an incarcerated defendant to seek post-conviction relief. These opinions misconstrue the state privilege of habeas corpus and misinterpret the state's Habeas Corpus Act, which codified the procedural process for seeking habeas relief, a process that has not materially changed since the General Assembly enacted the Act in 1868. The state therefore asks this court to set the case law back on track and to reverse and vacate the opinion of the Court of Appeals and to reaffirm the ruling of the Superior Court judge here. Addressing first the Court of Appeals opinions. So since 1976, the Court of Appeals has issued a series of now 5 opinions that have treated habeas corpus as if it could provide a mechanism for post-conviction relief of a defendant held pursuant to a valid final judgment. The first case was In re Stevens, Hoffman versus Edwards, Freeman versus Johnson, State versus Leach, and then finally that culminated with the Court of Appeals decision below in State versus Daw. Yet, for well over a century before the Court of Appeals issued these opinions, this court had interpreted the language of both the state habeas statute and the constitutional scope of the right available and held that a final judgment entered by a court of competent jurisdiction bars relief by habeas corpus to a person imprisoned pursuant to a judgment. The state listed a series of opinions from this court. The opinions on this point are numerous, dating back well into the 1800s and up through the 1970s.
So do you think there's any possibility that the constitutional, that this court's authority to issue that writ, given the language in the Declaration of Rights, would provide some area where it was available that's not covered by the statute? Do you think that's there? Do you think the statute's just so comprehensive that anything that could possibly be one of the constitutional grounds is covered by the statute?
Your Honor, I think if I'm understanding your question correctly, could the constitutional right exceed the grants of the statute?
Right, could there be some scenario out there where it's not really under the statute, but you say we still have the power as the court system to issue the writ because of what we have in our Constitution? It's restraint of liberty. The writ can't be suspended, that sort of thing.
Justice Dietz, I think the answer to the question is that this court has never interpreted the scope of the constitutional right that broadly. So obviously this court has the authority to define the scope of what constitutional rights are, particularly under our state constitution. And a statute enacted by the General Assembly can't limit this court's constitutional authority. However, in every opinion issued by this court since enactment of what is now the Habeas Corpus Act, which again was enacted in in 1868, this court has never ruled that the statute is unconstitutional because it somehow limits the authority of this court. Rather, this court has consistently interpreted the statute as if it provides a proper procedural mechanism for the constitutional right that is available. So in a string of opinions from this court, including State versus Dunn,
They can
State
interrupt her at
versus
any
Webb,
time with questions.
Ledford versus Emerson, In re Burton, In re Palmer. Again, this court has always construed the writ of habeas corpus. The means of seeking relief by habeas corpus is unavailable to a defendant who is being held pursuant to a valid final judgment entered by a court of criminal jurisdiction. And this court, since the founding of the state of North Carolina, the constitutional right of habeas corpus has been deemed limited, where once an individual is confined under processes that were consistent with due process, to be held because they committed a crime and they were found in the due course of law to have committed that crime, habeas corpus provides no mechanism for that individual to complain. Another point here is that this court has ruled in multiple occasions, like In re Holly and State versus Edwards, that habeas review is confined to the record and judgment and relief may be afforded only when on the record itself the judgment is one clearly and manifestly beyond the power of the court. So this court has consistently ruled that when a defendant seeks a petition for a writ of habeas corpus, when it can be seen from the application that he or she is being held pursuant to a final judgment, that's the end of the inquiry. And that's how the Superior Court here treated the petition for a writ of habeas corpus. When he determined that the defendant was being held pursuant to a valid final judgment, that was the end of the inquiry, and the request for the writ was denied.
I'm trying to read
So
through
there's
this.
an argument in the amicus brief
Amicus.
that
Amicus. I'd say amicus.
14-4
I'm not going to correct the Chief Justice.
doesn't apply here because effectively the danger posed by COVID amounted to some additional restraint that wasn't obviously authorized by the final judgment that led to imprisonment. Now, how do you respond to that argument?
Your Honor, the precedents of this court have never suggested that the fact that circumstances of confinement, that a defendant may be complaining about the way in which he or she is confined, somehow overshadows the fact that that individual is being held pursuant, when that individual is being held pursuant to a valid final judgment, habeas is not the proper mechanism to seek relief. So,
well, has our court ever addressed whether, I know you talked about the cases where we've said that habeas is not available once there's a conviction, but those cases where defendants were trying to challenge something improper about their conviction itself, which we said, habeas is not a substitute for direct appeal. None of those cases involved conditions of confinement, did they?
Your Honor, I think that's correct, and that this court has not specifically ruled on conditions of confinement. However, this court has treated as unilaterally prohibitive of granting habeas relief the fact that a valid final judgment exists. And the state's position is that because the defendant here is not challenging the validity of the underlying judgment or sentence, habeas wasn't the appropriate mechanism to seek relief. Now, obviously, I'm aware that COVID-19 raised some precarious concerns for specifically the prison population, and the state was tasked with providing a safe environment for those inmates. However, the fact that there was a crisis didn't somehow alter the scope of the privilege of habeas corpus. In addition, there were multiple mechanisms that incarcerated individuals during the pandemic had available to them to seek relief in these extraordinary circumstances. And those could have included anything from filing an administrative grievance with the Department of Adult Corrections to seeking a commutation of sentence or clemency from the governor, or pursuing an individual civil lawsuit against the entities that were holding them. And ultimately, that's what happened, and that's how the defendant here was able to secure his relief, was by a civil lawsuit where a settlement was reached with the governor. So obviously the COVID-19 pandemic presented circumstances that were pretty unusual. That was something that this court hasn't had to address at this point. The state, however, maintains that habeas corpus was not the proper mechanism for incarcerated individuals to seek relief under those unusual situations.
Well, I just have a quick question. As you noted that the pandemic is now thankfully behind us in a lot of ways. And so I do want to just ask you about mootness. And the Court of Appeals felt that the public interest exception should apply here because there were other cases pending. But I've sought in vain to find any pending case that would be impacted by the outcome of this case. Is the state aware of any reason why this case is not moot based on the notion that there's some other case pending that would be impacted by the outcome here?
Your Honor, there are several other cases in the Court of Appeals right now that are currently being held in abeyance for resolution of this case. The three I have listed are Edwards, and that's docket number 21778, State versus Williams, docket number 22671, and State versus Hicks, which is docket number 20665. And there may be more than that, but those are the three that I am presently aware of that are currently pending, being held in abeyance for resolution of DAW at the Court of Appeals right now.
And those are all cases where habeas is pending as opposed to a motion for appropriate relief?
Correct. Petitions for writs of habeas corpus were sought by the defendants. Addressing
habeas corpus,
the
they
question
want to be
of
released.
mootness, just briefly.
I want to take you back before I've got some mootness.
No, that's
too,
okay.
but
Yep.
before we move on from that, so going back, do I understand you to say, so in a quorum claim, for example, where we're creating through the court system a claim that wouldn't otherwise exist, we have said we won't allow that to happen unless you have no other adequate remedy at law. I heard you making a similar point about saying there were other things that could have been done, for example, bringing the civil suit, seeking injunctive relief to fix the conditions in the prison. I'm wondering, though, why logically that would have any impact on whether or not you have access to habeas. In other words, is there like a quorum type theory that you really should, habeas is a last resort if you can do these other things, or?
Your Honor, not that I'm aware of. I was just putting that out there more as an argument that the opposing counsel and the amicus brief filed in this case seemed to suggest that habeas was this lifeline, this last resort. So my response that there were other avenues available for relief in no way was intended to be an argument that if there were not other available mechanisms for relief, that somehow that would require this court to more broadly construe the privilege of habeas corpus. But rather to say that the legislature, administrative procedures, other mechanisms in state law do make those things available. So to the extent that the argument is made by opposing counsel that habeas corpus is a lifeline and this court should broadly construe it, the state would push back against that argument.
So, and just a clarification on the mootness, those cases that are pending in the Court of Appeals, are those also COVID era habeas petitions?
My understanding is that they are.
So, I mean, isn't the problem with that those cases are also moot? So it seems to me that like the public importance exception, we'd have to be able to see, at least I realize we're not going as far as like the capable of repetition yet evading review principle, but you'd at least want to be able to look and say, okay, the public importance is
smart people.
There's all these other people that need an answer to this similar question, but it seems to me that other people who might have claims also have those claims are moot, and so they don't really need an answer either. What's your response to that?
Your Honor, I think this case does qualify within the public interest exception for a couple of reasons beyond just the fact that there are pending cases in the Court of Appeals that raise the same question. So as the court is aware, under the public interest exception, an appellate court may, if it chooses, consider a question that involves a matter of public interest, is of general importance, and deserves prompt resolution. And I think another significant factor this court should take into account is the fact that we have now 5 published opinions from the Court of Appeals that misconstrue the scope of the privilege of habeas corpus and misinterpret the statute governing the procedure by which an individual can seek that relief.
Well, I want to allow you to finish your answer, but have a question about those 5 cases.
Okay. Can I?
Please do.
Okay, thanks. Yeah, so Justice Dietz, I think specifically there are cases like Hoffman versus Edwards, where the court used very expansive language to define the scope of the right available under habeas corpus. They stated, whatever the case may have been, it is clear now that the scope of a court's habeas corpus jurisdiction is much broader. And so the concern here, in addition to the fact that there are these pending cases raising the same question, is that litigants can rely on these cases, which are the most recent cases addressing the scope of habeas corpus, and seem to provide this broad, although the panels in those cases did not ever grant relief by habeas corpus, seem to use language that would suggest that this is a broadly available post-conviction remedy that the General Assembly has not yet authorized.
But you would agree that the General Assembly could authorize this broad relief, correct? I mean, they can't restrict habeas below what the state constitution requires, but they could allow relief in these circumstances. If the General Assembly wished to apply the statute this way, they could, right?
Your Honor, I believe so. So I believe if the General Assembly could alter the provisions in the statute that say, once there's a valid final judgment, whether or not that would be, I guess I'm not 100% sure on the answer to that question.
Well, the reason I ask that question is because of the legislative acquiescence argument that's been made in this case. And I think, we have Stevens from the Court of Appeals, if I'm getting right, the 5 cases you're talking about. We have Stevens from 1976, Hoffman's 1980, Freeman's 1988, Leach's 2013. Over all that time, it's been clear that's how the Court of Appeals is interpreting the statute. So it isn't the fact of legislative inaction in the face of that record over all those years, some suggestion that in fact the Court of Appeals is right. And this is an avenue of relief that the General Assembly intends to provide to the citizens of North Carolina.
Oh, she doesn't like that.
Your Honor, I don't believe the doctrine of legislative acquiescence would apply here, most importantly because the statute that governs the provision of habeas relief is really it's a procedural mechanism for an individual to pursue that relief. So I guess I would backtrack on my earlier answer, Justice Earls, and say it is the responsibility of this court to interpret the scope of the constitutional right. Now, can the legislature craft a statute where it gives the defendant new or different post-conviction remedies? Absolutely, and the General Assembly has done that by providing an opportunity for defendants to seek motions for appropriate relief.
I don't get the post-conviction
so the legislature certainly has the ability to provide new post-conviction remedies for defendants. Whether or not it could do that in contravention of how this court has interpreted the scope of the writ of habeas corpus, I believe that would fall to this court to determine the scope of the constitutional right.
Right, but we haven't said that the state constitutional right to habeas doesn't afford a remedy for allegedly unconstitutional conditions of confinement. We haven't said that as a court.
That's correct, Your Honor. And so if this court deemed it appropriate to expand the scope of habeas corpus, obviously it's within the province and discretion of this court to determine how to construe constitutional rights. The state's position, however, is that construing the privilege of habeas corpus that broadly would be inconsistent with a wealth of opinions that have been issued by this court over the past century.
I don't understand the underlying case in this one, but habeas corpus or show me the body.
Returning just briefly to mootness, because I know that's an important question in this case. Again, the state's position is that this is a matter of public importance based on the pending published opinions from the Court of Appeals, the pending cases before the Court of Appeals.
When you say pending, they've been heard and just no opinions been released?
Your Honor, I don't believe they've been heard.
How do you know they're being held because they're awaiting a ruling in this case?
Because the Court of Appeal issued orders holding them in abeyance pending resolution of the office.
And so they haven't been heard yet?
That's correct. That's my understanding, at least, Justice Riggs. Another point is were this court to determine that this case is moot, the argument has made by opposing counsel that the proper remedy would be simply to dismiss the case and leave the Court of Appeals opinion below undisturbed. The state suggests that that would be, if in the chance this court determines that the case is not or is moot, that rather the proper remedy would be to vacate the Court of Appeals opinion below rather than leave it in place. And that's based on an opinion from this court, State versus XREL Utility Commission versus Southern Bell Telephone and Telephone Company, issued in 1976, where this court stated that the better practice in this circumstance, meaning intervening mootness when a case is pending before this court, is to vacate the decision of the Court of Appeals rather than simply dismiss the appeal at the Supreme Court level and leave the Court of Appeals opinion otherwise
on the record
in place. So the state would ask this court, if it does determine that the case is moot, rather than leaving the Court of Appeals opinion in place, to go ahead and vacate that opinion.
But that wouldn't that wouldn't solve your problem, would it? To the extent that you're arguing that there is this series of cases from the COA that allow for habeas relief in circumstances that you don't think are statutorily permitted.
That's correct, Justice Allen. So the state's primary position is that this case, although moot, is in fact subject to the public interest exception because we have this series of Court of Appeals opinions that have interpreted habeas corpus too broadly. And
the state
would
wants
ask
to
this court
restrict
to issue an opinion in this case, determine
when habeas corpus
under
can
the
be
public
used.
interest exception, it's appropriate for the court to rule on these questions. Rather, my argument about intervening mootness is in the alternative. So in the event this court deems the case moot, the state would ask the court to vacate the Court of Appeals opinion.
So I have a statutory construction question for you. Obviously, there's a lot of argument in the briefing about the meaning of the term civil process in 17-33. And as I understand the state's position, it's that civil process is distinguishing civil process from criminal process. If we were instead to agree that as a matter of history, that the term civil process refers to non-military process, what impact would that have on your position that it's actually 17-4 that governs?
Your Honor, whether or not this court interprets the phrase civil process to mean civil process and criminal process, just not military process, or civil process to mean process in a civil case, really doesn't alter the state's argument about how the statute should be applied in the circumstances before the court today. So in the state's primary brief, I make an argument about basically the procedural process of habeas review. And under 17-4, the court who receives a petition for a writ of habeas corpus has to look at the application materials and determine right off the bat before it ever issues the writ whether or not it can determine if the defendant was being held pursuant to a valid final judgment. And here, from the application itself, the court could have made that determination, and so the state's position is that Section 17-4 required dismissal of the petition at that point. So 1733, that includes the phrase civil process, only becomes operative after a court issues the writ, return of the person who is holding the person who is being detained, issues a return on that writ, and then a hearing is held on return of the writ to inquire into the cause of the detention. The state's position is that we don't even reach that statutory provision because at the application point, the statute required that the petition be dismissed because it showed that the defendant here was being held pursuant to a final judgment in a criminal case, and he wasn't challenging the underlying jurisdiction or validity of that judgment. But as returning to your question about civil process versus just not military process, even assuming for the sake of argument that the court should have reached the statutory section 1733 sub 2, the state's position is that defendant here was not being held pursuant to any process. Rather, he was being held by virtue of a valid final judgment. So process is defined as typically, I don't have the definition right in front of me, but process is really being held in a pretrial posture. So a defendant is being held pursuant to, say, a warrant for arrest or an indictment or some other thing like that, some standard in pretrial process. But once an individual has gone through the trial and has been incarcerated due to a valid final judgment, that individual is no longer being held pursuant to any process. So for that reason, the state would argue that however this court interprets the word civil in 1732 really doesn't matter to the circumstances here.
But can no, please. No, go ahead.
As a follow-up to Justice Allen's question, one of the amici argues that in the context, and again, I understand this isn't the context here, in the context of a confinement for a mental situation, that if the strict rule that you're advocating here is applied in that case, then people would languish in mental institutions without a way to free themselves or get themselves free. And there was some argument that perhaps 1333 would provide some relief for that. Are you prepared to talk about that and address the issue that was raised in the amicus?
Your Honor, I think I can address it at least to the point where I would direct this court's attention to its opinion in Ray Harris, where and also as in the memorandum of additional authority filed by opposing counsel here, he also raised two cases that involve individuals who were committed due to reason of insanity and how they are released. The state would suggest that those cases and the case law governing kind of those mental health proceedings are distinguishable here because especially in the memorandum of additional authority filed, those commitments essentially were at that time made without any defined process by statute, and that was this court's primary concern was that you were basically relying on either the authority of a single judge or a clerk of the court to have an individual committed for mental health reasons, and then there was not a clearly defined mechanism for how those individuals would be released. That's not the case we have here. Where we're dealing with an individual who was incarcerated through a process where he was given due process, a trial, or excuse me, I can't recall whether or not he pled guilty, but received his confinement due to circumstances where he obtained due process. And for those reasons, those kind of mental health cases are not controlling to the circumstances before the court here.
Thank you.
She's got 2 minutes left.
Final question. So I think I understand your point here because I think you've stayed principled in the state's position. But if the state had created, like in addition to the Department of Corrections, the Department of Torture, and there was
that sounds fun.
a facility where certain people convicted of crimes and sentenced to prison were transferred for incarceration, where they were tortured all day long, the state's position is that's not the sort of restraint on a liberty that the framers intended to be covered by habeas, bring a 1983, but it's not a habeas case. Would you agree with? I realize it's a hyperbolic example, but that's your position? Yeah, Your Honor,
obviously I don't believe that this case in front of the court involves torture.
No, and I wasn't suggesting it was. I understand.
Yeah, the state's position, though, Your Honor, is that habeas doesn't apply in the face of a valid final judgment entered by a court of competent jurisdiction. So to the extent a defendant is arguing that his confinement, that he was being mistreated during confinement, there should be opportunities for that kind of defendant to seek relief, but habeas is not the correct constitutional or procedural mechanism to pursue that relief.
So what would be the right mechanisms?
Your Honor, so as the state has argued in its brief, filing an administrative grievance against the Department of Adult Corrections, filing a civil lawsuit, a 1983 claim, seeking clemency or commutation of sentence from the governor, filing a motion for appropriate relief is a statutory mechanism for a defendant to seek relief in certain post-conviction settings. So any of those could potentially be options for a defendant who is complaining about the conditions of confinement.
I don't think they like
those conditions.
what she's arguing.
Unless the court has other questions, I'll reserve my brief time for rebuttal.
Thank you, counsel.
Okay, we're going to bail on that. That was a lot of fun. That was very interesting. It was very cool. Awesome. It was fun. Thanks for playing, but we're going to go jump to a little bit lighter topic. Let's see. Judge Cedric Simpson's it. With the bailiff that everyone
does call the case. People versus Vera Alexander.
Everyone seems to like this one. Yes, Richard, that was a Supreme Court case here in my state in North Carolina. Let's see if I can tell you which one it was. The other side is getting up and arguing now, but they get another half hour. It's some pretty heavy stuff. I mean, I like it. It fascinates me, but it requires all my brain power to watch. That was the state versus Philip Brandon Daw.
Good afternoon, sir. What's your name? State your name. Vera May Alexander. All right. Let me just do something here real quick, Miss Alexander. Oh, come on.
You can do it, Judge. Really? Nope, that's not it. Give us 2 boxes. There we go. There it is. Thank you.
All right, Miss Alexander, this is your position to set aside a conviction. Yes, sir. Back from 1982. Yes, sir. All right. Tell me what you've been doing since this time of this. Well, I'm getting old. Okay, well, that's a good thing. I'm still here, though, right? There you go. I've been doing pretty good. I was working in a place in Florida that's why I've lived. And I came back up here because I have health issues and I'm trying to be around my family just in case if anything goes wrong. But I have been doing pretty good. I'm a member of Metropolitan Baptist Church and I go faithfully. I have a grandson that I'm trying to lead in the right direction because he's bad. I don't want to go down the road that I done went. Got it. So you're trying to teach the little ones that. Yeah, why I can. Okay. All right. Very good. The court would, in reviewing the application, set aside the conviction. That would note that they have responded and that an opportunity has been given to the Attorney General and prosecuting official to contest the application. There is no contesting the application. Court, given the allocation of Ms. Alexander, would find that the circumstances and behavior of the applicant from the date of the conviction to the filing of this application do indeed warrant setting aside the convictions, and the court does believe it is in the interest of justice and consistent with public welfare. Therefore, your petition to set aside is granted, and I've signed the order. Thank you, sir. Congratulations to you. Me too. If you want a copy of the order. Pardon? I said, now I'm going about my life now. There you go. There you go. All right. If you want a copy of the order, you can pick that up front at the counter. Okay.
She was wearing a dispensary shirt, which is just interesting.
Well, that was called the cases of the people versus Aaron Glover.
On behalf of Mr. Glover. Mr. Glover, if you can state your name for the record.
Aaron Glover. Go ahead, counsel.
Your Honor, this time and date set up for a motion to set aside. At this time, I do have a copy of the letter from the Attorney General with no objection to the motion to set aside. I do have a statement from Mr. Glover. He does have a family. He's about to be married. He started his...
Hold on. He's got a family. He's about to be married.
Yeah.
You went through that real quick. Go ahead. All right. Go ahead.
Congratulations.
Thank you. Thank you.
He has a career inside culinary arts that he just kicked off. He's working as a chef. He's avoided trouble for a long time. No jail or no tickets. He's been staying out of trouble, really focusing on his job and family. He recently had a baby, 3 months old. Has a 4-year-old son. His living conditions are stable.
Good on you.
He was attending Washtenaw Community College and Schoolcraft College. in this conviction, I think he would agree that it not only impacts him psychologically, since this isn't the type of person that he is, but it's difficult for him to get a job with this conviction on his record, and he has to explain it to employers, which can be quite embarrassing. He often finds himself also explaining it to family members. But he does contribute to his community. He volunteers at his son's school often, fundraises and chaperones events, and that he's just a changed man overall since 2013. So for all of these reasons, we would ask the court to set aside his conviction.
Mr. Glover, anything you want to tell me? Before I have all of my questions. What? Go ahead.
No, I was saying everything she said is true. And I'm currently going back to school of craft right now for my culinary arts program. My job that I work at is all seasons. They've been open for about 4 years now. It's a retirement home right there by right around the corner from here.
Yes.
Actually, not far at all. And for me to advance in my career, they're putting me through school, culinary arts school. So I'm starting that back up again. So
your employer is putting you through?
Yeah, the program, they have a program that help us put me through the help with the class or whatever. Yeah, just point me in the right direction in the classes I need to go to and
hang on,
everything like that. So everything is going good. Like I said.
Hello. Dang it.
Question and then an observation. So you're going to schoolcraft?
Yeah.
How come not Washington?
Oh, because Schoolcraft has the best culinary arts program.
Whoa.
He's a professor at Washington.
Oh, I'm sorry.
I'm a professor at Washington.
Oh,
I don't know why you said. I may just.
Well,
I might just have to deny this.
No. Let's take it back. I can transfer back.
Oh, okay, now you can transfer. The other thing is, now he went through, after Ms. Coons got done, he went through everything, talked about school, talked about it, said nothing about getting married.
Oh,
didn't say anything about. That is on you. We are going to send her this tape.
Well, I just went and picked out a ring, and we go on a cruise to Jamaica, and that's where I'm gonna propose and everything. So.
Oh, she doesn't know?
No, she don't. Well, she's expecting, but.
I hope she ain't watching.
No, she's not here. I'm here by myself.
Okay. No, but.
She's actually at class. Yeah, so.
She's at class?
Yeah, she go to Washington.
See? Yeah. You're the right person.
Yeah.
All right, Mr. Glover. The court, having heard the allocation of counsel and the defendant, and an opportunity have been given to the Attorney General and the prosecuting official to contest this application, and the court seeing and hearing none. The court does believe that the circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of this application warrant setting aside the convictions is in the interest of justice and consistent with the public welfare. Therefore, your petition is granted, sir.
Thank you. Thank you so much.
We've never watched this before, but this is wiping someone's
slate clean. And if you'd like a copy, you may pick a copy up front at the front counter.
All right, thank you.
All right, good luck to you at that other school.
Have a good day.
All right.
Good luck at that other school. This is wiping someone's slate clean after they've been convicted. They've had it on the record. They've changed their life. They've led their life in a pattern that shows that they're. Yeah, it's an expungement.
Court does call the case of the People versus Latoya. Is it Vizaga Noriega?
Richard Coons on behalf of Vizaga, Miss Vizaga Noriega. You can state your name for the record.
Toya Vizaga Noriega.
That's what I said. All right, go ahead.
Your Honor, this is the time and date set up for a motion to set aside conviction. I do have the letter from the Attorney General, which states that they have no objection. As to what she's been doing since this conviction, she has been on disability. She has severe anxiety and depression, and it's hard to be around people. But despite that, she has been volunteering regularly at Greater Faith Transition Center Church, where she helps package food, organizes it, and prepares it for pickup for individuals who are low income. She also successfully completed a term of probation. She took a theft class while on probation, and I think it taught her a lot. Overall, she's learned that taking things just isn't worth it and a lot more work at the end. So for those reasons, we would ask that the motion to set aside be granted.
Ma'am, is there anything you'd like to tell me?
I've never been in trouble before, and I happened to be taking someone to the store that day. So I just happened to be caught in the middle of it for taking that person to the store. So that's all I have to say. Thank you.
Questions?
So are you volunteering at the center that you were talking about at the?
Yes, at the church. Yes.
At the church?
In West Willow, yes.
Okay. And that's preparing for individuals who can't afford or don't have. Is that?
I probably want to say maybe don't have.
Got it. How'd you get involved in that?
I go to the church.
And this is part of what you do there.
Yes, on Tuesdays. And
something rewarding for you, or?
It actually makes me feel a little bit better when I get out and try to interact with people a little bit more, because it's been kind of hard for me to do it. So I've been trying to push myself to get out a little bit more. That would probably help with my anxiety and depression a little bit. So.
Got it. Okay. So it's probably hard to come here.
Yeah, I had to take something before I came in, but fine.
Okay, well, let me tell you what. If it means anything, I'm glad you did.
Thank you.
All right. Hearing the allocution of the defendant and counsel, when an opportunity have been given to the Attorney General and the prosecuting official to contest this application, court does believe that the circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of this application do warrant setting aside the conviction and is consistent with justice and consistent with the public welfare. Therefore, your petition is granted.
Thank you so much.
Sign that. If you like a copy, like with the others, you can pick it up front at the front.
Okay.
All right. Thank you.
This is cool to see. This is people changing their lives and getting a redo and getting the history of that conviction sort of wiped off the slate.
How are you doing?
Doing okay. What's your name?
Shanika Power.
All right. And you're looking to set aside 2 leases. Is that correct?
Yes, sir.
Well, tell me a little bit about what you've been doing.
Working, taking care of my kids. I got 4 grandkids. Trying to work, want to get a better job. Try to keep them focused, not to get in trouble. I grew up not doing that stupid stuff no more. I'm older now. Scared of the police, scared to be in trouble. I just work, take care of the kids and home.
She said scared of the police.
Scared of the police.
She looked right at you.
Right there. I look right over there, the police.
Yeah, I know. Scared of the police.
So I'm just working, taking care of my grandkids. That's about it. Want to set this aside. I'm a way older person, better person than what I was.
All right. You sure of that?
Positive.
Whoa. She didn't even hesitate. She didn't.
Not at all.
You're better than this.
Yes.
The interesting thing is whenever I'm doing these, I just say that you were always better than this.
Always.
You just didn't know.
Just doing dumb stuff at that time.
And in both of these cases, this one. Got it. All right. Court, in reviewing these petitions and hearing the allocution of the defendant, an opportunity has been given for the Attorney General and prosecuting official to contest the application, and court hearing none. Court does believe that the circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of this application do warrant setting aside the convictions and is in the interest of justice and consistent with the public welfare. And therefore, both the petitions as filed by the defendant are granted.
Thank you.
You're welcome. I've signed them, and like with the others, if you want a copy, pick it up as a front copy.
Thank you. You have a blessed day.
You do the same. You're welcome. Oh, you were waiting for her? Oh, I got it. Okay.
The dispensary
shirt
lady.
You take care, little one. Bye. He said, didn't even turn around, just said bye. All right. That's it for us.
All right. That's all they got on the docket. It was just the light work today. Very uplifting though. It was fun to see that happen. We don't get to see that very often. Well, we've done quite a bit today. We've had Supreme Court. We've had court hopping. The only thing we haven't had is a police chase. I think it's been good. It's been wonderful. I think we're gonna call it. It's a quiet day in court. There's not a lot going on. I realize there's one big case, but man, it is compared to what we just watched. It is night and day difference. Very, very heavy over there. But either way, I think we're gonna call it. If one of you wants to volunteer, no, just kidding. Don't. I don't want you guys to get in trouble because they do catch you. They do catch you. If something big happens, or if I can find a case, we're going to come on in the afternoon. Otherwise, I think I'm going to let you guys go early, and it's sort of a late time to take a lunch, but it's going to be a late lunch, but it's a long one. What are we supposed to do for the rest of the day, Jamie? I honestly I don't know. I don't know what to offer you. That's where I'm at. Judge Boyd. She went on break 2 minutes. 2 minutes before the guy in the white hoodie was due to be released from court. Yes, it's a snow day, Janelle. It is definitely a snow day. So she went on a break, so we don't have that. Thurston's been sort of quiet. Not a lot happening there. It's just a quiet day. I know we get to sit down. We can go back up to Thurston if you really wanted to and see what's happening. I'll take a peek before we leave just to see what's up.
Got to be able to get to work, and I love what I do. I'm at a great job. I have a good company and a good boss, and I can't be letting that stuff get away. About a year and a half later, I've been sober since the incident. Spent my 21st sober, but honestly, stopping the drinking after that was not hard. I was never a big drinker before, and now it's kind of more of having seen the effects and how dangerous things can go. Alcohol is not worth risking the safety of others, safety of myself, my freedom. It's not worth it. And I think as a man of 22 years of age, it can do you a lot of benefit not to be drinking, just in terms of your life and maintaining sobriety and clarity. I feel incredibly lucky to God and just the way everything panned out, that nobody was hurt, and that it was only a pull. There was no vehicles or anybody hurt in the car. I intend on maintaining my sobriety. Obviously, I got my eval this weekend and look forward to getting that into you. I apologize for the delay on that, and it was an expensive lesson I'll never make again. This has been probably the hardest year of my life since then, just, financially and, mentally. But I think surrounding myself with the right people has helped me move forward and try and be better than I was then and make the right decisions. Thank you, Your Honor.
All right. Thank you, Mr. Dawson. The court does appreciate your comments. And I think for a man of 22, you have a lot of wisdom. And I see that you've taken this to heart, and I believe you've taken a lot of steps that will prevent this from happening again. So the court is going to follow the agreed recommendation here. And I will impose all those days, but I'll suspend all of them on conditions that were already been outlined for you, about not committing any criminal offenses, not frequenting bars or taverns, not driving without a valid license and insurance, not consuming any alcohol, cannabis or other drugs, and not to refuse a breath test if requested. It sounds like you're on the path of sobriety, and I don't expect these to be an issues for you, but they're just part of your terms. So just make sure you understand that. And we will be expecting to see that evaluation for your drug and alcohol treatment. When it comes back, you will also be attending the DUI Victims Impact Panel as well. You mentioned, or your attorney did, that they can get these done really quickly. Do you need, 30 days, 45 days, Mr. Sue? What do you recommend to get these?
We're confident we can get it done in 30 days.
Okay. All right. leave restitution kind of open by later order. If there's something filed, we will address that at a future time.
I guess that's it. Karina, yes, we are going to do the button contest soon. The problem is I'm still counting. I need to have the total count myself. Man, I couldn't find that one.
Oh, no.
The judge, we thought the judge froze, but he did not. I can't find that one right now, but let's see. I think Ari would be willing to zoom in next time. For what?
All right, Mr. Dawson, I've signed the judgment and sentence, and we'll make sure you get a copy of this. And good luck to you, sir.
Thank you, Your Honor.
Thank you. Thank you, Mr. Soup.
Thank you, Your Honor. May I be excused?
We'll
Thank you, Mr. Holcomb.
Excuse you.
Okay. All right. Morning, Mr. White.
Morning, Your Honor. We can proceed with Ms. Marlo Brown.
All right.
His advertisement for his law company.
We've sent a waiver over to both Mr. Thompson and Mr. Holcomb. We're asking to strike the trial dates that have been set in this case, waive speedy trial for some ongoing investigation and motions. That's pretty much it.
All right. Marlo Brown, if you can hear me, if you could unmute your camera on if you have one.
Paging Marlo. Bueller.
Marlo Brown.
I'm here. I'm trying to unmute.
Okay, thank you.
Sorry about that.
I just want to make sure that you were tracking with us. So your attorney, Mr. White, indicates that you're still working on some things, and so you're asking to set over your dates a little bit.
Like the camera.
How far are we looking out, Mr. White, on that?
We'll just go with whatever the court prefers, Your Honor, 30 to 45 days.
All right. What's our speedy trial situation?
Here she is.
The waiver is through May 11th, Your Honor.
Okay.
Right. And Your Honor, just for the sake of my records, could I just, can the court just inquire as to the defendant's full legal name? Because I think that I may have a maiden name or a different name in my system, and I just want to make sure that the charging documents are correct.
All right. Ms. Brown, what is your true full name?
Marlo K. Brown. He may have Solpizio, which is my maiden name.
All right. Thank you. All right. So we will be sending these matters over. And Ms. Brown, let me make sure we got a good address for you just while you're here. Just give me a moment to have my computer catch up with me here. Are you still on, is it Ecliff Drive in Shelton?
It's 44.
Don't want to give away her address.
Ecliff, yeah. All right. Mm-hmm. All right. Well, we will see you back here on your new dates. And any questions, Ms. Brown?
No, sir. Thank you.
All right. Thank you.
The funny thing is that attorney,
thank you, Mr.
White.
Does the court have any information on when those dates might be, Your Honor, or will this just mail out?
In his screen, it probably looks right.
We will just mail them out.
He thinks he's got an advertisement over his head for his law services, but it's backwards for everybody else.
Thank you, Your Honor.
Thank you.
Amanda, you say you sent a link. I'll take a quick peek and see if there's something, if it's something we can go to. I might be able to go to the post office. I know I've got a package waiting. Okay, let's see. Ooh.
Any other attorneys ready on anything?
Anybody?
Your Honor, Amelia Hickok, I'm ready on Gabriel Naiguchi. I'm not sure if the state has received the completed plea paperwork. I just sent that over.
Was it sent to
Mr. Thompson?
Okay. Do you happen to have the email for Clerk Brenda So
Yes, I will send it over there now.
Thank you. I don't know if the plea paperwork's been looked at or not, so I may need to take just a brief minute to look over it and sign it.
That is no problem. I can split this one, and I will make sure that paperwork gets sent over.
Perfect.
Okay, just 1 second. 238-91795. 238-91795. Trying to go to this link. It's just not plain white. Plain right. And it just does not like this. Send it to my MacBook Air. Let's try that. Somebody's swinging their feet under the desk here. Okay, I've got the Harris County link. Let me see if we can pull this up. Just 1 second. See what's going on here. I think it's a criminal docket, which is good. We like that. It's over Zoom, but it's over IBM. So, Judge Juanita Jackson.
We did it back in December.
Yeah, I think I remember hearing that she don't have a receipt. What is the amount? Is she saying?
She's saying there's yeah.
What was supposedly damaged and what was the amount?
So what was damaged was a sink and a table, both. So the sink was about 180 and 250 for the table.
The audio is terrible. Let's see. You know I want to leave early. I can't go anywhere. My cars are all gone. By cars, I mean we own 2 vehicles. They're both in Raleigh. Right?
Thank you.
Mr. Jesus Ortiz.
And this is brutal on the ears. This is a tough one. I realize it's live, but these mics do not make it easy. Okay, we're gonna bail on that one just because it's rough. The sound is awful. Not sure what happened. We'll keep an eye on that one. We'll see if something happens. That might be a place we can go back to. It's just probably a noisy courtroom, and so it's lots of interruptions and stuff. All right, is Raleigh where the Bug Museum is? I believe so. They were at the Bug Museum. I don't know. I think they went to Raleigh. They headed that direction. She doesn't have a phone, so I have no idea. Mrs. Array does not like having a phone. Let's see. We could take a walk, go pet the cat. All these things I could do. I could walk to the post office. Just, pack a lunch and walk there and then hope that the package is not heavy that I have to carry back home. I could do that. I think that's all. I think we're going to go to lunch and maybe come back and maybe not. Is that fair? I think it's a fair deal. All right, a strolling lunch. I might go for a walkabout. What do you call it? What's in the Knight's Tale? What does he call it when when you just wander around? Remember when the guy was the one dude was in the buff, but that's irrelevant here. But what is it called when was he strolling? There's a term. I think I've asked this question before and I forgot what the answer was. It was something interesting. Going for a stroll, going for a walk, going for a meandering. Is it meandering? That might be it. All right. Thank you, everybody, for being here this morning. It's been a lot of fun. We are slowly coming up to a next big case. I think it's going to happen here soon. It's a quiet time in all the courts across all the land right now. It's very quiet. Occasionally we get a little break like that, and sometimes we need it. And I think this is one of those times. So I appreciate everyone being here. I enjoy spending the time with you today. We may, if something happens, if there's breaking news and my phone buzzes and I'm like, hey, this is going on, we might go live again this afternoon. But until then, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again, which will be no later than tomorrow morning, around 8:30, 8:45-ish. Not all who wander are lost. Natalie, I love that one. There's a YouTube channel, Wander something, a girl that goes on like strolls through the mountains. It's pretty cool. Guys, be good to each other. Have a wonderful afternoon. We might see you later on tonight. What is it? Is it Tuesday? I feel like something's happening tonight. I just don't know what it is. I should probably check my calendar. Trudging! That's it, trudging. That's the word. All right. You guys, catch you later. Be good. We'll see you. Bye.
Bring the jury.